All right, members, let's gather ourselves. I just want to remind you folks, we're in third reading. We have more third reading to go through. Regular list. So I want to kind of make sure we get everybody in the house. And we're going to start right now with a privilege of the floor. Representative Kinner.
Thank you, Mr. Speaker. Privilege of the floor.
Please proceed.
Thank you. Ladies and gentlemen, I am really proud to have my brother and his wife all the way from North Carolina, Stephen and Julie Kinner. Why don't you stand up? And let me tell you about Stephen and Julie. They lived in Casper for quite a while. They lived in Cheyenne for quite a while. And then also their banking career and teaching career took them also around Wyoming, and also were in Gillette, and also were in Jackson. And so please show them a big Wyoming welcome. Welcome.
Well, we're so glad you're here with us. So glad you're here with us. All right. I'm just scanning the room to see if we're missing a committee. All right, members, we're at that order of business of bills on third reading and final passage. The first bill for our consideration is Senate File 89.
Senate File 89, sponsored by Senator Cost. Public Utilities Safety Lights, an act relating to motor vehicles.
We have an amendment. Representative Washington.
Thank you, Mr. Chairman. I respectfully withdraw first reading or third reading amendment number 1.
The amendment is withdrawn. So again, members, we're on third reading. So this is your final vote. Am I gonna have to gavel the former speaker? All right. We're on third reading, final vote. We're going to call the roll. So gentlemen, thank you very much. Chief Clerk, House Bill Senate File 89 have been read 3 separate times. The question is, shall the bill pass? Chief Clerk, please call the roll.
Andrew, Baker, Banks, Bear, Blackburn, Brown, Burkhart, Burt excused, Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner, Fortner. Excused, Gray, Greer, Hallinan, Haroldson, Harshman, Heiner, Henderson, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermuller, O'Hearn, Olson, Ottman, Paxton, excused, Provenza, Roscoe, Schwartz, Sherwood, Simpson, Excused. Summers. Stiff. Stibar. Sweeney. Walters. Washit. Western. Wharf. Williams. Wilson. Winter. Yin. Zawanitzer. Mr. Speaker. Fortner.
Chief Clerk, I'm back.
Uh, We are on Senate File 89. Your vote?
Yes,
And I?
aye.
Okay. I'm closing vote. Are there any changes? Gray, aye to no. Heiner, aye to no. Paxton, excuse to aye. Further changes? Closing vote. The vote is closed. 46 aye, 12 no, 2 excused.
Senate File 89, having received the affirmative vote of the majority of the members elected to the House, Senate File 89 has passed the House. Next, Senate File 96.
Senate File 96, sponsored by Senator Hutchins. Homicide amendments, an act relating to crimes and offenses, being enacted by the legislature of the state of Wyoming.
We have an amendment. Representative Romero Martinez, please proceed.
Thank you, Mr. Speaker. I move third reading amendment number 1 to Senate File 96 and ask for your favorable consideration.
Please proceed.
Mr. Speaker, point of order.
Point of order, what's your point?
I don't believe this amendment is germane to the bill.
Well, I would, it's certainly long enough, but we'll talk about that in a minute.
Mr. Speaker, I'd like to call for a Rules Committee.
So Rules Committee, come to the front of the room, please. All right, members of the body, the Rules Committee has met and and had a good discussion. And I appreciate that. So after contemplation of the comments that were made, and I'm going to rule that this amendment is not germane to the bill. And certainly the bringer of the amendment can object to that, and then we'll go through that process. But at this point, I'm going to rule it as not germane. Representative Romero Martinez.
Thank you, Mr. Speaker. I object.
Seems like we've been here before. All right, ladies and gentlemen. All right. So the objection is debatable. I think that's how we've been doing this. So they still want the question. But if there's debate on the objection, Chairman Zwanitzer.
Sure.
And I think for the sake of time, let's just try to go once, twice, and then try to be done. So, I mean, members one time, second time, and we'll be done. So, Chairman Zwanitzer.
Okay, thank you, Mr. Chairman. I do agree with objecting because I do believe it is germane, and I shared with the Rules Committee that I had a very, what I believe, similar thing 15 years ago, that anytime we are talking about a crime, that bringing in what is the penalty and punishment for that crime is in fact germane. And so I believe the amendment does that. And I'm not sure if it's fair to ask what the Rules Committee informal vote was, but I believe it was 6-6 or 5-6. And so it is, you know, I wouldn't usually agree with fighting the chairman or questioning his judgment, but I believe it was close, that it's a policy question for the body.
So just so the body knows, a straw poll done by the Rules Committee is just that. And whoever's in the chair, whether it's the chairman, presiding officer, speaker pro tem, they make a ruling, and the objection is on that ruling, not on what the Rules Committee did. Representative Gray.
Thank you, Mr. Speaker. And you know, we've been wrestling with germaneness all session. I think this is probably the 5th, 6th time we've had this discussion. And I didn't get up yesterday, but I do think it is important for us, you know, I was really wrestling with whether to get up to get this right. And I think there's a little bit of common sense we got to bring into this. And it was back to the representative from Casper, a little bit east of me, the district I represent. It's about surprise. And there is a little bit of, you got to think about how do you react to this? This is about how do you handle homicides, a certain situation. It's not about repealing the death penalty entirely. And that's what this amendment is. This is a whole new policy, and it's certainly a surprise. And I think that we've got to start getting this germaneness thing right. I think sometimes we got it right. Sometimes I don't think we got it right. But I definitely think this one, the objection should be, we should vote no on the objection and not hear this amendment because it's just totally, really a different topic. Thank you.
Representative Oakley, and then Chairman Olson.
Thank you, Mr. Speaker. I would agree with the last speaker. I think all we have to do is take any sort of broad look at this, and we're all aware that this was not at all the main purpose of this bill. And we're on a 3rd reading of the 2nd House, and we're changing discussion from whether it should or should not be a crime when a pregnant woman is murdered, for a separate one for the unborn child, to a complete repeal of the death penalty, which we all know is a huge, controversial, emotional topic, and it has not been in front of this body via this bill in any way. I don't think there's anybody that taking a broad look at this would think that this is germane or appropriate. I think it's an inappropriate amendment. I also believe that it's unconstitutional according to the Wyoming Constitution. Article 3, Section 20 and Article 3, Section 24 say that no bill should be amended as to change its original purpose. Clearly, that's what this would do. And Section 24 says the bill is to contain only one subject which shall be expressed in the title. And again, clearly, the repeal of the death penalty, nor discussion about that is in the title. So I believe the amendment is, I agree with the ruling of the chair. I would ask you to uphold that. I think this is an improper amendment, and I think it violates our Constitution.
Thank you. Chairman Olson.
Thank you, Mr. Speaker, and I respectfully object to the decision of the chair. I think the Rules Committee was split on this, and I divorced myself from the Rules Committee discussion. I didn't divorce myself from that vote. I want to divorce myself from this objection, but I just simply can't, because I think I want to be honest about the bill and the amendment and what we're talking about. And I think we all should be. And I have never been under a false impression about what the homicide amendments bill is about. It's about life, and it's about protecting an unborn life. The word unborn is in the bill. It's about creating a new penalty in law, a first-degree murder penalty for the taking of an unborn life. And the death penalty is not a separate conversation, because the penalty for first-degree murder is death. So how is that a different conversation? That's in the bill. It's already in your bill. The bill creates a new charge of first-degree murder for the taking of an unborn life, and it applies a penalty for doing so. All this amendment does is say, okay, if we're going to create a new criminal penalty, a new criminal charge of first-degree murder for taking an unborn life, all this amendment does is say, what should the penalty be? That's the question before this body. That question has existed in the bill the entire time it's moved through the process. It's just the question you thought the question was already answered for you. And that was the status quo. That was that if I wanted to protect an unborn life, then I had to accept capital punishment for a violation of that offense. Now you get both questions in front of you, to protect an unborn life and to protect life until natural death. I think they're very consistent. I think they belong together. I think there's no better time to discuss capital punishment than along with the charge of first-degree murder. So just very respectfully believe that right before we went to lunch, we had a conversation about discussing life. And here we are again. If these are the issues that we were brought here by our constituents to discuss, then let's not get bogged down in the procedure, and let's discuss them, because I think they go together very strongly. So very respectfully ask that you'll rule the objection.
Thank you. Chairman Flitner.
Mr. Speaker, thank you. And I cannot be more eloquent than the previous speaker. For me, this bill has always been about life, and I would like to hear the amendment. Thank you.
Thank you. Representative Ottman.
Seems like this is going to be quite the debate. On the bill, it's the bill itself, which is what this is for, is relating to crimes and offenses, creating new offenses for first and second degree murder, providing definitions, and providing for an effective date. There is no punitive or what the penalty should be. This is just getting it into statute, what we're talking about, how to define it, and how it is to be acknowledged. So I would be against the amendment. Thank you.
Other members, first time, Madam Minority Floor Leader.
Thank you, Mr. Speaker. And I too will respectfully oppose the ruling of the chair. And just to follow up from the last speaker, I ask you to turn to your bill. And what you will see in your bill is the headings of first degree murder, semicolon penalties. Semicolon penalties. So anytime that you're talking about an offense, you're also talking about a penalty. And so what this amendment does is go into that penalty. Thank you.
Thank you. So members, I want to be clear about where we are. So we are debating, certainly we're debating the bill for all intents, or the amendment, but we're talking about the objection. So the vote you'll be taking is on the objection. And if you vote in favor of the objection, you're overruling the chair, and it is germane. You're saying it is germane. I is germaneness, yes. No means not germane, if that's the easiest way to put it to you. I, it is germane. No, not germane. Representative Washut.
Thank you, Mr. Speaker. For me, members, the test is who would show up to testify during committee of the whole or in committee on this bill. If this bill was about death penalty repeal, we'd have had a different group of our citizens and constituents come to the committee, participate in those discussions than we had when this bill was about the murder of a child being carried by a woman, right? And so to me, that's the test. If the same group of people would be present regardless, then the topic's germane. But if you get an entirely different population of citizens testifying in favor or against your bill with the amendment or without the amendment, then I don't think it's germane, and I stand in favor of the chair's ruling.
Majority Floor Leader Summers.
Mr. Speaker, thank you. On and against the objection. And I just want to go back to Article 3, Section 20 of the Constitution. No law shall be passed except by bill, and no bill shall be so altered or amended on its passage through either house as to change its original purpose. This is clearly changing the original purpose of the bill. Murder of an infant or an unborn versus a repeal of the death penalty. It's clearly a different purpose. On and against the objection.
That's right. We're where we are. Any other member? Representative Williams. Representative Williams.
Thank you, Mr. Speaker. In agreement with the chair, the amendment's not germane, clearly a violation of our Constitution, and clearly not a friendly amendment to the sponsor of the bill, and offensive. Thank you.
Any other debate? Any other debate? Representative Romero Martinez.
Thank you, Mr. Speaker. Of course, I think it's germane. And again, I want to draw our attention back to Section 402. Number 1, every amendment proposed must be germane to the subject. The subject, which is murder or attempted murder, manslaughter, is the subject. It might be specifically to one group of people at a specific age in their life, but it's still murder. In Section 2, to determine whether the amendment is germane, the question to be answered is whether the amendment is relevant, appropriate, and natural, logical sequence to the subject matter. 25 and a half, almost 26 years ago, the CEO of the Universal People of God proclaimed in ecclesiastical notation, of which I will not say exactly what the notation was, declared that when dealing with issues of life, that death penalty is included. And so, therefore, I would say that since it's the same subject, killing, murder, manslaughter, it is germane. It's only specifying another area of that. So any disagreement is offensive to that body and is misguided. Thank you, Mr. Chairman.
Thank you, Chairman Greer.
Thank you, Mr. Speaker. I raise an objection to the amendment and support the decision of the chair. And so we've wrestled with germaneness for near 10 years. And it kind of moves and we're a little fluent. Some people think we should be very liberal in interpreting it, and others think we should be very strict in how we interpret it. Our views always kind of go along with the subject matter of the amendment. Just face it, we're human beings, right? But some of the arguments that have been brought forward concerning our Constitution. So let's look directly to that. are very relevant. And I go from the good gentleman from Natrona County with his words are right on, spot on with this. Why do we talk to a single subject? And why do we say a bill shall not be altered to a point that it goes upon or against its original purpose? And the reason for that is because in this long process, to which we're basically 3 steps away from a bill. So in the other 12 steps to get there, it is debated. It's not just debated by the other house. It's not just debated by us. It's not just debated by our committees. It's debated by the public. It's for us making public policy to be able to listen to our constituents, to listen to the state of Wyoming and take these issues and come together on solid policy. That's why our Constitution has those 2 provisions that were spoke of. That's why when I look at these, and somebody may think my votes on the Rules Committee over the last 6 years have been back and forth, but quite frankly, I look at it and I say, okay, is there a rational relationship between what the amendment is doing and what the original intent of the bill was? And do we follow? Do we have that tie? And do we fall within the scope of it? Those are the things that we have to look at. And in this scenario, I do not believe. The issue that this amendment brings forward is a significant policy issue, that needs and deserves full debate by every member of the state of Wyoming and every one of us listening to our constituents and bringing our own hearts and our own beliefs forward with it. Not an amendment on 3rd reading after it's gone through more than 7/8 of the process. And that 7/8 of the process has precluded that debate and that discussion. So, Mr. Speaker, I applaud you for your wisdom in your ruling. Thank you very much. I'm going to vote no on the objection.
Representative Larson Lloyd.
Thank you, Mr. Chairman. This has been a fun one to watch. I'm against the death penalty, and I'll vote no, but I'm going to vote no on this. But for you new people, this has just been fun to watch. These are masters. These are masters of statutory procedure and knowledge. And you can get a lot done for the good of your constituents and for the good of your state as you understand how these procedures work. And my hat's off to them. It's just been fun to watch, but I'm against the amendment. I support the speaker.
Any other members? Other members? Trying to wrap up maybe a first time for members, first time for any members? First time? All right, let's go to second time. Representative Gray.
Thank you, Mr. Speaker. We'll go quick here, but I urge a no on this, to no on the objection, to sustain the ruling of the chairman and reject the objection. And it is very important we get this right. I know there's been a lot of discussion, but if you're too narrow, we only meet once a year, you're preventing us from being able to reach our full potential or even close to it. If you're too wide, you got chaos, okay? I think we're in chaos mode now on this one. And this bill creates a criminal charge for taking of an unborn life. It is a specific situation it is dealing with. This bill's been brought many times over the past 3 decades, actually been vetoed once. But this amendment is saying in every single situation, every single homicide situation, you're taking away the possibility of a death penalty. That's why it is no longer germane. Because it takes it from this one situation and then says for every single homicide situation, suddenly we're going to remove the possibility of the death penalty. So I'm against the amendment, but I'm also don't think it's germane. So I urge a no vote to reject the objection and to sustain the ruling of the speaker. Thank you.
Any other members? There's still debate, so thank you. Madam Minority Floor Leader Conley.
Thank you, Mr. Speaker. I'm going to ask you to vote aye. And let's face it, there's questions about bringing this up at the 3rd reading. I was part of those discussions, right? Let's face it, I was a no on this bill. I was a flat out no on this bill until having that discussion, like we all do, and like we should. You talk to people and you try to figure out how do you get to a yes. And you know what? This is the way that I can get to a yes on this bill because it makes sense to me, right? Adding in, right, taking away the death penalty as a punishment to homicide, going in with the name of the bill, homicide amendments, gets me from a no vote on this bill to a yes vote on this bill. And that's what we do in here, right? That's what we do. We have those conversations and we talk to each other about a particular bill. So to me, it makes it absolutely germane because it's absolutely personal. It makes me a yes where I was a no. So I'll ask you to vote aye.
Thank you very much. Further members, Representative Romero Martinez.
Thank you, Mr. Speaker. Just a couple of comments. I think it's really important to see when a no vote becomes a yes vote because they see the value in all life. And we just spent all morning talking about life, and now we don't want to talk about life. We need to protect all life from the womb to the tomb. We can't cherry pick and be cafeteria life choice pickers, I don't think, but we may be. And I thank you for the time and I yield.
Thank you. Any other members? Any other members? So members, I want to be clear about what we're voting on. So we're voting on the objection. If you vote aye, you are agreeing with the objection and the amendment is germane. If you vote no, you're voting it is not germane. Aye, you're with it germane, it is germane. No, it is not germane. Further discussion. Further discussion. Chief Clerk, please call the roll.
Andrew. Baker. Banks. Bear. Blackburn. Brown. Burkhart. Burt.
Aye.
Clausen. Clifford. Connolly. Crago. Duncan. Eklund. Air. Flitner. Fortner.
No.
Gray. Greer. Hallinan. Haroldson. Harshman. Heiner. Henderson. Hunt. Jennings. Kenner. Knapp. Larson Lloyd. Larson Dan. McGuire. Martinez. Nyman. Newsom. Nicholas. Oakley. Obermuller. O'Hearn. Olson. Ottman. Paxton. Provenza. Roscoe. Schwartz. Sherwood. Simpson excused. Summers. Stith. Stivar. Sweeney. Walters. Washit. Western. Wharf. Williams. Wilson. Winter. Yin. Zawanitzer. Mr. Speaker. Closing vote. Are there any changes? Closing vote. The vote is closed. 20 aye, 39 no, 1 excused.
So by your vote, you've ruled, the body has ruled regarding the germaneness. Representative Romero Martinez, would you withdraw the amendment, please?
Mr. Speaker, I withdraw the amendment and urge aye on the bill.
Thank you very much. Senate File 96, having been read 3 separate times, the question is, shall the bill pass? Chief Clerk, please call the roll.
Andrew. Baker. Banks. Bear, Blackburn, Brown, Burkhart, Burt,
Aye.
Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner, Fortner,
Aye.
Gray, Greer, Hallinan, Haroldson, Harshman, Heiner, Henderson, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermuller, O'Hearn, Olson, Ottman, Paxton, Provenza, Roscoe, Schwartz, Sherwood, Simpson excused, Summers, Stith, Stivar, Sweeney, Walters, Washit, Western, Wharf, Williams, Wilson, Winter, Yin, Zawanitzer. Mr. Speaker, closing vote. Are there any changes? Blackburn? Closing vote. The vote is closed. 50 aye, 9 no, 1 excused.
Senate File 96, having received the affirmative vote of the majority of the members elected to the House, Senate File 96 has passed the House. Next Senate File is 102.
Senate File 102, sponsored by Senator Driscoll. Unclaimed cooperative utility deposits and payments, an act relating to cooperative utilities.
We have an amendment. Representative Air.
Thank you, Mr. Speaker. I move third reading amendment number 1 to House Senate File 102 and ask for your favorable consideration. Remember, this is the bill we passed on second reading yesterday regarding the ability of a cooperative utility to keep their deposits that had been unclaimed. Following the meeting yesterday, I spoke to the state agency that handles our unclaimed property. And I found that if the last known address of the owner of the unclaimed property is out of state, or in the case of a corporation, if that corporation is domiciled out of state, then the unclaimed property is transferred to that other state. This is either done by the holder of the unclaimed property when they file that report, or once a year, our state unclaimed property folks transfer that to the state of where the last known address is located. And that's under a reciprocity agreement that the state has with all the other states regarding unclaimed property. So I proposed this amendment to, well, basically all it does is take out the second reading amendment. We passed it yesterday, but it does include some of the provisions in that second reading amendment. And it also includes some of the provisions of the second reading amendment that we did not, that was withdrawn yesterday. It will just allow the unclaimed property deposits or advance payments to the cooperatives to be held by the cooperative. If they remain unclaimed after 5 years, which is the total time that was in the 3-year plus the 2-year before it became unclaimed in the amendment yesterday, and the utility makes a good faith effort to locate the rightful owner, then the unclaimed property could be used by the cooperative for community benefits. Thank you, Mr. Speaker.
Thank you. Any member for their first time? First time, Chairman Flitner.
Thank you, Mr. Speaker, on and for the amendment and for the bill. I just want you to know what some of those credits are used for. As a member of a local cooperative, I can tell you that it goes towards scholarships. It goes towards helping your local county fair. those credits go toward any number of organizations in your community that have a handout. So those dollars, if unclaimed, would just go right back into your local communities. So I would urge your aye vote on the amendment and your aye vote on the bill.
Thank you. Further discussion on the amendment? Further discussion? Seeing none. Members, we are voting on third reading, amendment number 1, Senate File 102. All those in favor, please say aye. Those opposed, no. The amendment is adopted. Senate File 102, having been read 3 separate times, the question is, shall the bill pass the House? Chief Clerk, please call the roll.
Andrew, Baker, Banks, Bear, Blackburn, Brown, Burkhart, Burt,
No.
Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner, Fortner,
No.
Gray, Greer, Hallinan, Haroldson, Harshman, Heiner, Henderson, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermuller, O'Hearn, Olson, Ottman, Paxton, Provenza, Roscoe, Schwartz, Sherwood, Simpson, Summers, Stith, Stivar, Sweeney, Walters, Washit, Western, Wharf, Williams, Wilson, Winter, Yin, Zawanitzer. Mr. Speaker. Closing vote. Are there any changes? Olson, no to aye. Burkhart, aye to no. Washit, aye to no. Crago, no to aye. Further changes? Closing vote. The vote is closed. 41 aye, 19 no.
Senate File 102, having received the affirmative vote of the majority of the members elected to the House, Senate File 102 has passed the House. We're at that order of business of request to concur with Senate amendments to House bills. Members, this was the message that you received yesterday at afternoon from the chief clerk. The first message for our consideration is 338 on House Bill 10. Chairman Greer.
Mr. Speaker, I move message 338 regarding House Bill 10, COVID-19 Large Business Relief Program. Mr. Speaker, I'd like to turn the explanation over to the good gentleman, the Chair of Transportation.
Thank you, Chairman Burkhart.
Thank you, Mr. Speaker. Ladies and gentlemen, what this amendment does is includes in the bill a statement that if any CARES money comes back, the Appropriations Committee, in effect, the Appropriations Committee will allocate it. And that was agreed to with the Good Appropriations Committee. So I'd ask for your aye vote on concurrence.
Thank you. Any discussion? Any discussion? Representative Gray.
Thank you, Mr. Speaker. Not trying to belabor this, but I'm not a big fan of this one. I had some concerns about the bill, but then originally the whole point of the bill was that this was out of the initial COVID relief funds. And now this is saying that it could be out of the next tranche. And I thought the policy decision we had for the most part made was that we were going to make those decisions in a special session at once. And so the way I understand this, I think it goes against, it is a carve out on something, the direction we've wanted to go. And I'm going to vote no. Thanks.
Any other member, first time? Member, first time? Member, first time, second time? Members, we're on voting on the motion to concur with Senate amendments to House Bill 10. A majority of the elected members is required. Chief Clerk, please call the roll.
Andrew, Baker, Banks, Bear, Blackburn, Brown, Burkhart, Burt,
No.
Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner, Fortner,
No.
Gray, Greer, Conflict, Hallinan, Haroldson, Harshman, Heiner, Henderson, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermuller, O'Hearn, Olson, Ottman, Paxton, Provenza, Roscoe, Schwartz, Sherwood, Simpson, Summers, Stith, Stivar, Sweeney, Walters, Washit, Western, Wharf, Williams, Wilson, Winter, Yin, Zawanitzer. Mr. Speaker. Closing vote. Are there any changes? Provenza, aye to no. Clifford, aye to no. Further changes? Closing vote. The vote is closed. 33 aye, 26 no, 1 conflict.
By your vote, you have voted to concur with Senate amendments to House Bill 10. Next message, 338. On House Bill 102, Chairman Greer. Next message is number 339, House Bill 102, Chairman Greer.
Mr. Speaker, I'll move message 339, which is House Bill 102, Wyoming Preference Act of 1971 amendments, Mr. Speaker, and I'll come up and turn things over to you for an explanation. Okay. Oh, Mr. Speaker.
Thank you, Mr. Speaker Pro Tem. Now you know how I've been feeling all day. So members, I'm going to ask you to concur on this. The Senate did 2 things. The first thing is, as you recall, this went from 1 year down to 90 days in the original bill. And then with our colleagues, I should say, my apologies, our colleagues down the hall, their amendment gave some authority to the department to modify those days, 3 months. And the concern that was brought in committee, as I presented it to our brothers and sisters at the other end, was that, you know, how do we deal with those students during the summer? And should we have a little shorter requirement for them so we can accommodate them? 3 months, obviously, sometimes is not summer break. It might be 2.5 months, or there might be summer school issues. So this was to give some latitude to the department. through rulemaking, of course, which has its own process, to adjust that days. Now, I'll tell you, I'm a little hesitant on it because they could also up the days. But let's say for the sake of purposes that it's meant to give some flexibility, some latitude to the department. We've made our policy statement going from 365 days to 90 days. I don't see them, going back up to 90 days. I think that's unlikely. So I think that I'm, like I said, it could cut both ways, but I'm comfortable that there's an understanding of the policy that is being adopted. The second part of this is the page 2, line 8, and then the delete entirely, Mr. Speaker Pro Tem, lines 9 through 23, and then 2 through 9. This was ways to establish residency for military members, et cetera, et cetera. That is currently covered in rule. And so our colleagues at the other end said, can we leave it there? And certainly there's no harm, no foul. They'll continue to establish the policy through rules. The most important things in the bill were the 90 days and the 9 months, and those remain intact, solid in the bill. So I'd ask for your vote aye on concurrence with message 339, House Bill 102. Thank you.
Any members wish to speak on message 339, concurrence request to House Bill 102? Any members? No? Okay, we are voting on a motion to concur with Senate amendments to House Bill 102. The majority of the elected members is required. The chief clerk will call the roll.
Andrew, Baker, Banks, Bear, Blackburn, Brown, Burkhart, Burt,
Aye.
Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner, Fortner,
Aye.
Gray, Greer, Hallinan, Haroldson, Harshman, Heiner, Henderson, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermuller, O'Hearn, Olson, Ottman, Paxton, Provenza, Roscoe, Schwartz, Sherwood, Simpson, Summers, Stith, Stivar, Sweeney, Walters, Washit, Western, Wharf, Williams, Wilson, Winter, Yin, Zawanitzer. Mr. Speaker. Closing vote. Are there any changes? Closing vote. The vote is closed. 51 aye, 9 no.
By your vote, you have voted to concur with Senate amendments to House Bill 102. Next message for our consideration. Message 343 on House Bill 38. Chairman Wilson.
Thank you, Mr. Speaker. I move message 343 and ask for your aye vote on concurrence. Folks, this was the bill that we discussed, basically triaging mental health and substance abuse services to the folks in most urgent need. The members down the hall made 2 changes. You can see on your amendment, they brought in our current language on what the organizations were, but added an A. That's just why that paragraph is there. And then B, they brought in tribal services, which I think was a good addition. And then the amendment on line 16, they were concerned that perhaps the most urgent categories somehow left out indigent people who had urgent needs, which it didn't, but it made them feel better to specifically say for the subsequent tiers, that those tiers are for those indigent people who didn't otherwise qualify under tier 1 and 2. So it's basically a belt and suspenders, and it's fine. So I would urge an aye vote.
Any members, any questions? Any members on the concurrence request? Any members? Members, we are voting on the motion to concur with Senate amendments to House Bill 38. A majority of the members elected is required. Chief Clerk, please call the roll.
Andrew. Baker. Banks. Bear. Blackburn. Brown. Burkhart. Burt.
Aye.
Clausen. Clifford. Connolly. Crago. Duncan. Eklund. Air. Flitner. Fortner.
No.
Gray. Greer. Hallinan. Haroldson. Harshman. Heiner. Henderson. Hunt. Jennings. Kenner. Knapp. Larson Lloyd. Larson Dan. McGuire. Martinez. Nyman. Newsom. Nicholas. Oakley. Obermuller. O'Hearn. Olson. Ottman. Paxton. Provenza. Roscoe. Schwartz. Sherwood. Simpson. Summers. Stith. Stivar. Sweeney. Walters. Washit. Western. Wharf. Williams. Wilson. Winter. Yin. Zawanitzer. Mr. Speaker. Closing vote. Are there any changes? Duncan, aye to no. Further changes? Blackburn, aye to no. Nyman, aye to no. Further changes? Closing vote. Fortner, do you want to be no to aye?
Yes, I do.
Okay. No, Fortner, no to aye. Jennings, aye to no. Further changes? Closing vote. The vote is closed. 41 aye, 19 no.
By your vote, you voted to concur with amendments to Senate amendments to House Bill 38. The next concurrence is Reconsiderations Message 344 on House Bill 150. Chairman Nicholas.
Thank you, Mr. Speaker. I would move for concurrence on message number 344 for House Bill 150, and I'll tell the explanation for your no vote. And I'll turn the explanation over to the good representative from where the water sinks.
Representative Larson Lloyd.
Thank you, Mr. Chairman. This is this is on House Bill 150, which is the State Budgeting and Expenditure Authority. When it went down to the other side, the Senate really added some good language to the bill in 3 amendments. You'll recall that we've, in this bill, we talk about when and how the executive branch can appropriate funds coming in like we've had with the federal funds lately, and in using the B11 processes and other processes. We defined a new emergency fund that he can use. And what they did is they added some additional, I think, good sideboards on it that says anytime we get federal dollars and maybe we don't use them for a program, but it impacts the state up to over $10 million, then we have to do timeout and give a chance for the legislature to consider that in a special session. And that can be in a situation like on a maintenance of effort or a pass-through on a, where it would change the requirements of the state. We didn't have that in the original bill. And then they also contemplated and brought in another provision that I thought was really good to make sure that, that when we consider this, that it doesn't impact our taxing or appropriation authority in any manner. And we've seen some of that as we've discussed on the floor here about how as we go through the budget processing and we're receiving these new funds, that if one section of our budget or of our state agencies is cut disproportionate, that it can impact how you use the money. And so they looked at that and says we need to bring that in as well. And then on the maintenance of effort. So with all of my positive remarks, the question would be is why would we vote not to concur? And that's because as I was sitting down with our good LSO staff and making sure I understood all of these amendments, he found a couple of technical errors. And if you look at the bottom of page 2, this is just one of them. There's actually 3 of them. But if you look at the bottom of page 2, there's a reference to page 8, line 13, and it says after types insert and from federal funds as provided under paragraph C, that should be a B. And he just was hitting his head and saying, okay, this would be the easiest way to do is not concur. We'll do a conference committee. There's 2 other similar actions. And so we had asked that you vote no, and we're working with the other side. We'll have a conference committee. As soon as that committee is appointed, we'll try and do that hopefully yet today and get this done and bring it back and concur. But we like everything that they've done, but we need you to not concur so we can fix the technical corrections.
Any other discussion on the report? Any other discussion on the message? So members, you've heard the request. I just want to make a note, this could have been handled through a revisor bill too, but this seemed like a quicker way to do it, so we could move it faster. So we're voting on a motion to concur with Senate amendments to House Bill 150. A majority of the elected members required. Chief Clerk, please call the roll.
Andrew. Baker. Banks. Bear. Blackburn. Brown. Burkhart. Burt.
No.
Clausen. Clifford. Connolly. Crago. Duncan. Eklund. Air. Flitner. Fortner.
No.
Gray. Greer. Hallinan. Haroldson. Harshman. Heiner. Henderson. Hunt. Jennings. Kenner. Knapp. Larson Lloyd. Larson Dan. McGuire. Martinez. Nyman. Newsom. Nicholas. Oakley. Obermuller. O'Hearn. Olson. Ottman. Paxton. Provenza. Roscoe. Schwartz. Sherwood. Simpson. Summers. Stith. Stybar. Sweeney. Walters. Washit. Western. Wharf. Williams. Wilson. Winter. Yin. Zawanitzer. Mr. Speaker. Closing vote. Are there any changes? Fortner, no to aye. Is that correct?
Yes, it is.
Fortner, no to aye. Burt, no to aye. Is that correct? Burt, no to aye. Correct?
That is correct.
Burt, no to aye. Blackburn, I to know. Further changes? Closing vote. The vote is closed. 9 aye, 51 no.
By your vote, you have voted not to concur with Senate amendments to House Bill 150. Conference Committee, Larson Lloyd Chair, Stith and Andrew. The next message for our consideration is message 345 on House Bill 95. Chairman Flitner.
Thank you, Mr. Speaker. I move message 345 to House Bill 95, and for an explanation, I will hand it over to the good chairman of corporations.
Chairman Zwanitzer.
Thank you, Mr. Speaker. I'm pleased to ask you for an aye vote after 8 years on this bill. But it looks like a very lengthy amendment because they kept, our good colleagues down the hall kept trying to amend the same section until third reading when they just took it out. So what you need to know about the road-killed wildlife bill, since the amendments when it left this body, you'll remember there were 3 ways to take road-killed wildlife. You get a letter of previous authorization, a scientific permit, or what we would all commonly understand. If you hit it, you could call the Game and Fish and get a certificate. So what they did is take out that entire prior authorization language. So really what you think of, if you hit an animal or see someone else hit it, you could call the department, and they left in what was Romanet 3, but took out the other 2 ways, and the scientific permit still also were in statute. 2, they had an amendment that you cannot donate any road-killed animal to a nonprofit or a charity for distribution of food. 3, they tightened up the language there in Romanet C on the bottom of page 3 to say nothing in this section shall authorize the taking of wildlife or possession of any illegally taken wildlife. I think the department brought that suggestion and it just tightened up the language. And then 4, and the interesting thing that developed over there after way too much conversation, on page 4, they basically made a claim that if YDOT gets to the carcass before you do, it's YDOT's, and they stake claim. So I wasn't going to fight that one. All around, some good amendments over there. Certainly brings the intent of the bill forward, and would ask for your favorable aye vote.
Anybody want to get to the mic next? Chairman Greer.
Thank you, Mr. Speaker. I'm going to be a no vote. I'm actually quite concerned about the race to the carcass. And I don't know if that should be for the citizenry or for our agency. So I'm a no vote.
Anyone else want to speak on the message? Further discussion on the message. So we are voting on a motion to concur with Senate amendments to House Bill 95. Majority of the elected members is required. Chief Clerk, please call the roll.
Andrew, Baker, Banks, Bear, Blackburn, Brown, Burkhart, Burt,
Aye.
Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner, Fortner,
Aye.
Gray, Greer, Hallinan, Haroldson, Harshman, Heiner, Henderson, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermuller, O'Hearn, Olson, Ottman, Paxton, Provenza, Roscoe, Schwartz, Sherwood, Simpson, Summers, Stith, Stivar, Sweeney, Walters, Washit, Western, Wharf, Williams, Wilson, Winter, Winter, Yin, Zawannetzer. Mr. Speaker. Closing vote. Are there any changes? Closing vote. The vote is closed. 44 aye, 16 no.
By your vote, you have voted to adopt Joint Conference Committee number 345 on House Bill 95. My apologies, members. All right, we're now at that order of business of consideration of Joint Conference Committee reports. The first report for our consideration is Joint Conference Committee number 1 on House Bill 49. House Bill 49. Representative Simpson, Chairman Simpson. And members, I just want to make a note for the members of the body and the public. Joint Conference Committee reports are just like amendments, so they're on the website. They're on the website. So if you pull up the website, the page, there'll be under amendments, the Joint Conference Committee reports are there. Please proceed, Chairman.
Thank you, Mr. Speaker. So while you're turning to that, so you can see it in front of you, if you go to the Amendments tab, it's at the very bottom. And I'll visit with you a little bit about it while you're finding that, since you're skilled now at multitasking. There were really House Bill 49 was the agency fee revision bill. And there was kind of two issues at hand between the two bodies. The most important issue was the House's position that the parolees and individuals on probation should not be challenged with monthly fees. The members at the end of the hall were very courteous to us. They saw how passionate we were about that. And so they actually conceded that completely to us. We were expecting to reduce those fees, but they conceded to us. The second item had to do with a distribution of fees from an unrelated department. We felt less compassionate about that, and so we allowed them to have that item. So it was a nice compromise. Mr. Speaker, I move Joint Conference Committee Amendment number 1 to House Bill 49 and request your favorable consideration.
Any discussion on the Joint Conference Committee? Any discussion? Members, we are voting on the Joint Conference Committee number 1 report to House Bill 49. Majority of the members elected members required to adopt the report. Chief Clerk, please call the roll.
Andrew, Baker, Banks, Bear, Blackburn, Brown, Burkhart, Burt,
Aye.
Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner, Fortner,
Aye.
Gray, Greer, Hallinan, Haroldson, Harshman, Heiner, Henderson, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermuller, O'Hearn, Olson, Ottman, Paxton, Provenza, Roscoe, Schwartz, Sherwood, Simpson, Summers, Stith, Stivar, Sweeney, Walters, Washit, Western, Wharf, Williams, Wilson, Winter, Yin, Zawannetzer, Mr. Speaker, Duncan. Closing vote. Are there any changes? Closing vote. The vote is closed. 47 aye, 13 no.
By your vote, you have adopted Joint Conference Committee Number 1 report on House Bill 49. Next Joint Conference Committee is Joint Conference Committee Number 1 on House Bill 73, Chairman Zwanitzer.
Thank you, Mr. Speaker. And so what I need to say is pursuant to Joint Rule 2.4, that I move the House recede from our non-concurrence and adopt the following Senate amendment. And so, ladies and gentlemen, this basically would be if we did not have a conference committee and we had approved the Senate amendment. I believe I was up here at this mic 2 days ago and said I had questions and we needed to go talk to the other body. It's fair to say I've been on a lot of conference committees, but none where the longer the 6 of us talked, I think we disagreed more and more on what we should do. And so after about an hour of going through the issue, and as you know, on Joint Conference 1, you have to stay between where the 2 sides are. So really it was the amendment on compensation. And this is a bill on gestational agreements that came from this body, and the Senate put I'll read the wording. Compensation is limited to expenses related to prenatal care, delivery of the child, and other costs, including the cost of lost opportunity directly connected to the pregnancy. So we are receding from a non-concurrence and agreeing to that language. And it will basically, let me take you back to what I believe was the crux of the bill and why it was brought. It was if you have a surrogate carry your child, you should not have to go before the court and pay adoption expenses to adopt your own child. And so if we agree to this concurrence, what will basically happen is if you meet all the parameters set forth in the bill, you've lived in Wyoming, you're Wyoming residents for a year, and you go through your compensation and you have all this in your gestational agreement to turn over, you do not have to pay adoption fees to arguably adopt what would otherwise be your child. This doesn't prevent any of the other, I think, nefarious actions that some of your emails and that we talked about on this floor. Those would still be permitted as they have been for decades, that if people wanted to come in and have surrogates, they would then go through the regular process of having to pay, the significant adoption fees to go through that process. So I think your joint committee realized there was not going to be an agreement. And so at least 2 of us in this body said, we'll just proceed and wish the bill well and hope it gets passed. I believe there might be some other thoughts that are forthcoming, but I would ask you to vote yes on receding from our non-concurrence.
Thank you. Members, first time on the non-concurrence or motion to non-concur recedents. Chairman Wilson.
Thank you, Mr. Speaker. I'm going to vote no on concurrence, and I'll just say the chairman of our committee very fairly stated of what went on in the conference committee. We made a really lengthy attempt to resolve the issue of the amendment, which I think was put in there to try to reduce incentives for using this beyond what the stated intention of the bill was. I feel that, one of the main reasons we weren't able to accomplish that is because although the discussion on the floor was always about if I may say, the sperm and the egg being from the 2 people who will eventually sign the document to be the parents, the actual text of the bill does not do that. And we didn't open up the Wyoming Parentage Act to amend this method of parentage in. So I'm just going to vote no, because I don't feel like we could fix the bill to actually do the stated intent even. So I'm going to vote no.
Thank you. Chairman Greer. On the recedents.
Yes, thank you, Mr. Speaker. The bill doesn't need to be fixed. I asked for a concurrence vote when this first came up. And again, there are greater issues at play, and there's greater policy concerns at play with this particular issue. And we talked about that. Okay. Surrogacy goes on right now within the state of Wyoming. The reason this bill came about was a result of a Wyoming husband and wife having, it was another family member carry their baby because they could not have a baby. And what we found out is that within the different judicial districts within the state of Wyoming, there's different views on how that should be followed. Okay, some judicial districts say you had to go completely through the adoption process. Okay, so rather than going into some of these other issues, which I think are policy decisions for us to debate and discuss what we want to do in Wyoming down the road, this was narrowly defined with the sideboards to address the issues regarding what happens when you have a husband and wife. And in the case that I was looking at, it was actually a sister-in-law that carried the child, simply a more dealing with the birth certificate only. Now remember, with the signing of 2 affidavits in that situation, the father's put on the birth certificate. No questions about it. That's law. So I guess when I looked at this, I go, okay, Mike, you're a very open-minded individual. So equal rights for women. Give the mother the same right. Okay. It was very simple. There are other policy decisions out there that deal with the beliefs of individual people regarding surrogacy. But keep in mind, this bill has nothing to do with that. Those surrogacies, those other things, all these evil things that people have brought in and thought about are going to go on with or without this bill. What this bill does is really help a loving husband and wife be able to have somebody take their egg and their sperm and carry a child to full birth into a loving family. And it does it without the added step of going through the adoption. So as I'd asked before, vote yes on this rescission. It's a good bill. Thank you.
Any other member? Any other member? Any other member? So members, just to be clear, if you vote aye, you're voting to advance the bill. This will be your final vote on the bill. If you vote no, we're not going to recede from our non-concurrence. So aye, you're voting in favor of the bill as it stands, and no is against the bill as it presented. Chief Clerk, we're voting on Conference Committee number 1, Receivers Report to House Bill 73. Majority of the members is required to adopt the report or to recede from the non-concurrence. Chief Clerk, please call the roll.
Andrew. Baker. Banks. Bear. Blackburn. Brown. Brown. Burkhart. Burt.
Aye.
Clausen. Clifford. Connolly. Crago. Duncan. Eklund. Air. Flitner. Fortner.
No.
Gray. Greer. Hallinan. Haroldson. Harshman. Heiner. Henderson. Hunt. Jennings. Kenner. Knapp. Larson Lloyd. Larson Dan. McGuire. Martinez. Nyman. Newsom. Nicholas. Oakley. Obermuller. O'Hearn. Olson. Ottman. Paxton. Provenza. Roscoe. Schwartz. Sherwood. Simpson. Summers. Stith. Stivar. Sweeney. Walters. Washit. Western. Wharf. Williams. Wilson. Winter. Yin. Zawanitzer. Mr. Speaker. Brown. Excused. Closing vote. Are there any changes? Closing vote. The vote is closed. 38 aye, 21 no, 1 excused.
Members, by your vote, you have voted to recede from non-concurrence on House Bill 73. Standing committee reports.
Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom is referred Senate File 15 engrossed, temporary licensing and permitting authority 2, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Blackburn, Clausen, Clifford, Duncan, Air, Hunt, McGuire, Roscoe, Swanitzer. Representative Swanitzer, Chairman. Mr. Speaker, your committee number 7, Corporations, Elections, and Political Subdivisions, to whom was referred Senate File 28 engrossed, Motor Vehicles, Security Interest Perfection, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Blackburn, Clausen, Clifford, Duncan, Air, Hunt, McGuire, Roscoe, Swanitzer. Representative Swanitzer, Chairman.
Thank you. Vice Chair Larson.
Thank you, Mr. Chairman. Your conference committee on House Bill 150, that'd be Representative Stitt and Representative Andrew, will be meeting down in room 113 on adjournment with our colleagues from the other side.
Thank you very much. Further announcements on any conference committees, if there are any? I don't recall. Mr. Majority Floor Leader.
Mr. Speaker, I move that the House resolve itself into committee of the whole.
You've heard the motion. All those in favor say aye. Those opposed, no. Representative Henderson.
I thought it was
You need a
rubber.
rubber one.
Sorry.
The committee of the whole will please come to order. First bill for our consideration, Senate File. Senate File 34. What's your pleasure? Reading clerk, read the bill.
Senate File 34, sponsored by Senator Steinmetz. Born alive infant, means of care, an act relating to public health and safety. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom is referred Senate File 34, born alive infant, means of care, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Flitner, Hallinan, Ottman, Romero Martinez, Stivar, Wharf, Wilson. Noes, Representative Clifford. Excused, Representative Connolly. Representative Hallinan, Vice Chairman.
You've heard the reading of the bill. What's your pleasure? Chairman Wilson.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the recommendation that Senate File 34 do pass. There are no amendments, and I would turn the explanation of the bill over to the good chairman from House District 26.
Chairman Flitner.
Thank you, Mr. Chairman. Members, while we may have spirited debate on the floor about when life begins and how pregnancy affects both the rights of a mother and a child, it is my hope that we can all agree that once a child is born alive, all rights apply equally under the law. We have seen evidence this last year in Wyoming that we will go to extreme measures to save just one human life, exemplified in the measures taken to fight COVID-19. Today, I ask you to consider Senate File 34, which seeks to refine language currently in statute in order to clarify the means of medical care for an infant who survives an abortion and is born alive. As many of you will remember, this bill is an old friend to this legislative body. It passed overwhelmingly in both houses in the Wyoming legislature in 2020. I would contend the bill is even more important in 2021 as we see policy changes on the national level. So we'll go through the bill. As you see, it would amend 35.6.104. And on the bottom of page 1, it brings in new language. So I will just read you the new language beginning at the bottom of page 1 and going on to page 2. The commonly accepted means of care that would be rendered to any other infant born alive shall be employed in the treatment of any viable infant aborted alive. Any physician performing an abortion shall take medically appropriate and reasonable steps to preserve the life and health of an infant born alive. And section 2, this act is effective July 1st, 2021. I would note too that the definition of viability is found at 35.6.101, subparagraph A, Romanet 7, and it states, that stage of human development when the embryo or fetus is able to live by natural or life supportive systems outside the womb of the mother according to appropriate medical judgment. And that is the bill. And if there are no questions, I'll call for the question.
Question being called. All those in favor of Chairman Wilson's Representative Sherwood.
Thank you, Speaker. It is with deep respect for the bringers of this bill that I just feel like I need some more clarification on the definition. If you could help me walk through commonly accepted means of care, and who determines that? Is it the physician? Is it the nurse? Is it the mother? That is just a little bit fuzzy for me. Thank you.
Chairman Flitner.
Mr. Chairman, thank you. I would assume that would be the commonly accepted means of care that any physician would take.
Thank you. Question being called. All those in favor of Chairman Wilson's motion to when the committee of the whole rises to report it, do so with the recommendation Senate File 34 do pass. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. Senate File 34 is passed committee of the whole. The next bill for your our consideration is Senate File 157.
Senate File 157, sponsored by Senator Whitman. Property rights, limitation on local authority, an act relating to cities and towns. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred Senate File 157 engrossed, property rights, limitation on local authority, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Blackburn, Clausen, Eklund, Fortner, Heiner, Larson Dan, Western, Wharf, Winter. Representative Eklund, Chairman.
You heard the reading of the bill. What's your pleasure, Chairman Eklund?
Mr. Chairman, I move that when the committee of the whole rises to report, it do so with the recommendation that Senate File 157 do pass. And I turn the explanation over to my colleague from the north central part of the state up against the east side of the Bighorns.
Thank you. Representative Western.
Thank you, Mr. Chairman. So this is a pretty straightforward bill and it's centered around property rights. And so what it really does is this, is it just adds clarifying language to statutes saying that cities or towns cannot zone through improvements. That if they want to zone, that's fine, but they have to do it through the zoning process and they can't do it through any kind of improvements on private property. So a sewer hookup or any kind of improvement like that. What it basically just says is you have to respect the zoning law as the property is currently zoned. The bill says that towns that there can't be any kind of changing of property rights via sewer connection or force any other different property use that that wasn't already authorized through zoning. Only zoning regulation is allowed to do this, not through sewer pipe connection or any kind of municipal improvements to a property. Basically what it does is it prevents backdoor zoning through leveraging connections for improvements. Municipalities shouldn't be able to do this. And this bill just makes very crystal clear in state statute saying that they can't do that. Any kind of improvements have to go through the zoning process. And so, yeah, that's basically what the bill does. And I stand for any questions.
We have an amendment, Chairman Eklund or Majority Floor Leader Summers.
Mr. Chairman, I'd like to move Committee of the Whole Amendment number 1 to Senate File 157 and ask for your favorable consideration. So, ladies and gentlemen, one thing I always am concerned about when I'm down here is unintended consequences. And so when I looked at this bill originally, I looked at really, there's only 2 sentences to the bill. And you go in there and you look at the first one is notwithstanding, first of all, look at what title we're in. We're in 15.7.101, which is public improvement. And it says, notwithstanding any provision of this title, no city or town shall condition the provision of any public improvement under subsection A of this section on the inclusion of deed restrictions on a property or properties. And then it goes on the other side that restrict the uses that are allowed under applicable zoning regulations. And then there's the second sentence that says nothing herein shall contravene the discretion of cities and towns to deny connection to the municipal sewerage system for utility related reasons. And so when I looked at it, there was a disconnect in statute between sewerage and public improvement. And then I found out more about the issue. And really the issue revolved around a circumstance in the county north of me where I don't know whether there was or wasn't, but there was the perception that the town was going to require affordable housing based upon a hookup to sewer. And so after I thought about this for a while, I just said, let's narrow it down because my concern with the bill is written. And when you talk about any deed restriction, so does that include a right of way? So for example, if you were a city and you had, and you were going to provide sewerage out into the extraterritorial area, and somebody said, well, we want to hook up to your sewer. And the town says, well, yeah, well, you can hook up to my sewer, but we need a right of way through you to get the sewer onto the next guy. And so there's all kinds of deed restrictions. And so for all kinds of reasons, things could happen. And so I thought it would be best to just narrow it down. And I talked to the parties that came on this issue. And I got a consensus around this language. And so basically what this says is it goes into that piece of statute on sewerage. And it says, notwithstanding any provision of law to the contrary, no city or town shall condition the connection of a municipal sewer system to a property on the inclusion of any deed restriction for that property or any other property that requires the development or provision of affordable housing. Nothing herein shall contravene the discretion of cities and towns to deny connection to the municipal sewerage system. And I think that was even up for debate as the way the bill was originally crafted, is whether a town could actually deny. And so then subsection B just defines affordable housing. So I bring this back to really the issue that was at hand. And like I said, I visited with the parties and the parties support this, and I would encourage your support. Thank you.
Discussion on the amendment. Representative Western.
Thank you, Mr. Chairman. So I think this is a good amendment, to add some clarity to the bill and context, and I would consider a friendly amendment. So please vote aye. Thank you.
Thank you, Chairman Nicholas.
Thank you, ladies and gentlemen. I think this amendment tightens up the bill, but I can tell you that this is not related to just one community. It's important all across the state. Both as a city attorney and as a practicing lawyer, I have dealt with this issue on more than one occasion, and I think it's a necessary restriction. So on and for the amendment and for the bill.
Other discussion on the amendment? Question being called. All those in favor of committee of the whole amendment number 1, say aye. Opposed, no. Amendment number 1 is passed committee of the whole. Back on the bill. Representative Schwartz.
Thank you, Mr. Chairman. So I am on and against the bill. I'll start just by talking, this bill, although it applies generally to the state of Wyoming, the origin of this bill comes from my county. And this is not a unique experience. I think I've spent more time at the podium talking about Teton County bills than any other subject since I was elected to the legislature. So I want to make a few things clear right at the beginning. First of all, no application has ever had a deed restriction required on it in order to be connected to a sewer system in my county. No sewer application has ever been denied in my county. There have been no losses of property rights or valuation of property based on sewer connection in my county. So these are just facts. So let's get to a little higher altitude and look at what's going on with this particular bill. You might note the Senate file number. It was the very last bill filed in the Senate, and there are no sponsors coming from the House. So it's let's just call it a last minute bill coming in to address a situation that might or might not have occurred in Teton County. I got a lot of experience with zoning in Teton County. I was a planning commissioner for 8 years. I was a county commissioner for 12. I'm pretty sure I know more about zoning in Teton County than anybody else in this room. This is a complicated issue. Almost all zoning issues in Teton County are complicated. That doesn't mean they are done without due process, a lot of deliberation, a lot of public input, and more importantly, a lot of legal input to make sure the zoning regulations we have conform with the law. There's a lot of information that's been provided to all of you related to this application, and I would argue none of it is false, but not all. There was more than one application, and it's very important to understand what was going on with the multiple applications and the reasons why they were dealt with in the way they were dealt with. I'm not going to get into that now. I've already broken my 30-second rule. I'm going to be here a little bit longer. But if you want to talk to me about it later, I would be happy to discuss it. But what's important to understand is that there were two completely separate applications, and there was rationales why the first one was denied and the second one was approved, and the second one is now waiting for that sewer hookup, to which we have no reason to believe it will be denied. So back to what my problem is. Once again, I'm at the podium talking about a bill brought to deal with issues in Teton County. It's tiring. We shouldn't be having to deal with this. These should be resolved within Teton County. These are local control issues related to duly electeds in Teton County and the town of Jackson. I would be cautious. We have set a precedent repeatedly in this body and the one down the hall that encourages this kind of action. And at some point, it's not just going to be Teton County. It's going to be your counties where your local electeds are going to have their authority challenged because somebody with a reason and probably the means is going to come here and try and get statutory relief when the relief should have occurred in the county where the problem took place. So I could go on, but now I'm at 2 minutes and that's way over my record. I really urge a no vote on this bill. Thank you.
Representative Yen.
Thank you, Mr. Chairman, members. So, I mean, I think I want to reiterate a little bit, but I also want to dive into the difference between this and other discussions where the legislature gets involved because we thought that there was a conflict that was resolved in a way that we think that a policy decision needs to be made, right? And so this isn't one of them, honestly, because the resolution hasn't happened yet. We're in the middle of the process to determine whether or not this goes forward. And when the local elected officials are dealing with it, if any developer can just come down, get a bill passed while we're in the middle of a process, we've put negotiating power in one side against the other, when I think what we should do is let the process play out. And if we think that the legislature needs to make a decision based on a conflict where we think that local control wasn't the right answer here, then we can do that. But if we start making decisions while we're in the middle of a process, I think we're gonna end up seeing way more developers come down to the legislature with a bill in hand, trying to weigh it for one side or the other. So I would ask you to vote no on the bill. Thank you, Mr. Chairman.
Chairman Greer.
Thank you, Mr. Chairman. So I'm an aye vote on this bill, and I guess I didn't see Teton County referenced in the bill, and maybe there's a set of circumstances where that applies. But the simple fact is we need to look at what this bill is doing, okay? And we do have a very complex set of planning and zoning and regulations that deal with the boundary between a county and a community and a municipality and an overlap. So if you're within a certain area, you're going to have to connect to the sewer. You may not be allowed the right to a domestic water right. There's a lot of different things that come into that. And it's this transition as cities grow, right? We want them to grow. And so, you know, an interesting thing, it comes back to our Constitution and our law and our beliefs as Americans is that, you know, we have a right to our property. Our property shouldn't be taken by someone else, in particular the government. Okay, there are extreme cases and we recognize eminent domain for the need for power lines and for the need for a road, for the improvement, for the overall greater good. And it has to be a very strong and compelling reason to have it. But when we start looking at what is most concerning to business and now property owners are what are called regulatory takings or administrative takings. And they're subtle, they're very subtle. And so when we allow, so we say somebody has to connect or they cannot have their own septic system and that's an environmental quality issue and it's a greater good issue and they have to connect to municipality. And that municipality uses that to go ahead and impose additional regulations, additional rules, additional restrictions upon your own property. That becomes one of those regulatory takings. It becomes one of those administrative takings. And those are the things that I think most of us are down here to prevent against. And that's what we're doing here. We're just saying, hey, now you read the bill and the bill says that if there's not sewer capacity, ran into this as a developer in my own community. If there's not sewer capacity, you don't get to hook up to the sewer. Because you can't. If they can't take the goods and there's not room for it, there's no room for it. But if there is, there's no reason. Okay, do you have to pay for it? You betcha. It's fine. But to start taking away and taking sticks out of the bundle of sticks of your property rights is absolutely wrong. And that's what this bill is doing. I'd encourage an aye vote. Thank you.
Further discussion, Chair, Representative Banks.
Thanks. I would encourage a no vote. I get concerned whenever we see more restrictions on what our municipal or county governments can do, and we're placing those restrictions here. We all know that it's much easier for a constituency to show up at a city council meeting or a county commission meeting and fill those chambers and argue their points with those people that they see every day than it is for them to get here to Cheyenne to express their concerns or their opinions one way or the other. So I think it's best that we leave these kind of decisions to the municipal or county government than it is to create statute here at a statewide level that is maybe less approachable. So I would encourage a no vote.
Question being called. All those in favor of Chairman Eklund's motion that when the committee of the whole rises to report, it do so with the recommendation that Senate File 157 do pass as amended, I believe. Say aye. No, those opposed say no. Senate File 157 is passed committee of the whole. Next bill for our consideration, committee of the whole, is Senate File 130.
Senate File 130, sponsored by Senator Driscoll, Charter Schools, an act relating to charter schools. Mr. Speaker, your committee number 4, Education, to whom is referred Senate File 130 engrossed, Charter Schools, respectfully report, same back to the House with the recommendation that it do pass with the following amendments. Ayes Representatives Andrew, Brown, Nyman, Paxton, Summers. Noes, Representatives Connolly, Harshman, Newsom, and Obermuller. Representative Paxton, Chairman.
You've heard the reading of the bill. What's your pleasure, Chairman Paxton?
I move that when the committee of the whole rises to report, it do so with the recommendation that House Bill 130 do pass, and I turn the explanation of the bill over to, I forgot who it was. 130 is charter schools. Representative Summers.
Majority Floor Leader Summers.
Mr. Chairman, thank you. We're a little unorganized. And so
We're
did
doing
the,
good.
Mr. Chairman, did the good chair move the standing committee amendment? So, Mr. Chairman, I would like to move standing committee amendment number 1 to Senate File 130. And so just a little bit on this bill first. So this was a bill that was brought out of the Senate to revamp Wyoming's charter school laws. And so currently in statute in Wyoming, a charter school can only be created really by the vote of the school board. And so what this does, and you can go through all the ins and outs of all the differences, but basically what this bill does is it says there's going to be 2 authorizers. So it calls them authorizers. One can be the school district like it is currently. And the second authorizer can be the SLIB board, the State Land and Investment Board, our four electeds. And then you can go through all the different changes it does between what we currently do. I would just broadly say that this charter school bill loosens up even more restrictions than normally occurs and the regulations. It would allow, you would say, more opportunity for more different kinds of charter schools. I'm not speaking in favor of this bill. I'm just trying to represent the bill to you the best I can. And so now I'm going to come back, Mr. Chairman, back to the standing committee amendment. And so, Mr. Chairman, as you look at the standing committee amendment, I'm going to walk you through the bill with the standing committee amendment. And so probably the biggest change, and it was an amendment of mine in committee, probably the biggest change is in the authorizer. And so I told you before, it was the SLIB board and the school district. And so what this standing committee amendment does is takes it back to the superintendent of public instruction, but upon a vote of the people. And you can do the vote of the people 2 ways. And so first of all, what area are we talking about? Well, it can be as small as a voting district or as large as a school district. And so currently in statute, you can organize a charter school within a school district. The idea, well, voting district, there was a discussion about what if a small town in Wyoming worried about their viability in a school system, could they form a charter school, and how could you possibly organize that? So the reason I go to a voting district is for that reason. And so how does that play out? It can play out 2 ways if by a vote of the people. One is it's a petition of the people, by the people, to do this. And the second is an application to the superintendent, and then she would put it on the ballot for the vote of the people. And the reason that this was brought, and I think passed in our committee on the vote of the people, is that the SLIB board does not really have any relationship back to the people. A school board does, but you can say, well, they're influenced by that system. We need another voice. So the voice really is the people. And so that's why we went away from the SLIB board back to the vote of the people. And so that's in generalities, Mr. Chairman. And then I'm just going to kind of walk you through page by page so you all can see that. And so it'll conform through the bill with this amendment, where anywhere where you kind of see SLIB, you'll see some sort of language that's superintendent of public instruction. And at any time, if the good representative from far up northeast there thinks I'm off track, he can give me a wink or a frown or something, and I'll try to reel it back in, Mr. Chairman. And so you can see page 2 is just conforming to to that, really the meat of it, the meat of the amendment is that on page 3. And on your amendment, it starts on page 1 and really rolls through 2 and much of 3. And that is all the language around how you get that authorizer. And then really the rest of page 3 is conforming. Then you go on page 6, I think, let's see. Yeah, page 6. I'll just go down the amendment as well here. Page 6, that's conforming. Just conforming language on the superintendent. Then you go on to page 9. That's just conforming language as well, provided that the superintendent shall be, limited to specific election approved, the charter school, that on and on. And then you go on page 11 now page 11 is different. Okay. I've been talking about the main amendment. And now this is this is another big piece of the standing committee amendment. So if you look on page 11 of the bill, you'll see that much of that whole page is struck out. And what the committee did is put that page back in. And really that is the process by which a charter school can be different than an ordinary school, and the process that they would go through to do that. And so it's, pursuant to a contract, a school district may waive, that's fine. The state board may waive state statutory requirements or rules. So we just put all that back in. Bottom of page 11, we strike the new language. Top of page 12, we strike new language through charter and the period on line 4. And then we leave in nothing in this subsection shall be deemed to exempt the charter school from those 3 things. And then if you go on, really from there, another big change on page 14. And that is what the bill said is if the State Loan and Investment Board is the authorizer, the board may instruct any appropriate school district to lease unused or underused school facilities to a charter school. And I think your good committee number 4 just felt that was a step too far and that shouldn't happen. Now, if it's a school district, if a school district decides to form that and give up their facilities, that's a different story, but we didn't think that should happen. You go on, I'm going to continue on. 19 is just basically conforming language. 20, basically conforming language. 21, conforming language. 22, conforming. 23, conforming. I think there's one more bigger one in here. 25, conforming. And well, there's 2 big ones. There's one right at the end. And then page 29. And as you can see, this is a large bill. I mean, it's a large bill. It took a while to digest. So on page 29, top of the page 2 through 7, because it's no longer the State Loan and Investment Board, but it's the superintendent, there's no reason to submit, for her to submit to her own agency. So really that section is not needed. It would just go directly to WDE anyway. And then on line 30, on page 30, line 19, we would reinsert, starting on line 19, we'd make that a capital P and reinsert stricken language, basically so we could understand the potential effects of this charter school on other schools. So that's pretty much what we're doing from there through page 31. 32 is conforming language. 33 is conforming language. 34 would be a major change from the bill. And that would be on pages or on lines 6 through 14. The current language in the bill says any charter school may offer a private pension. And we strike that and make it consistent with the current charter. school language, which is no, they have to use the state pension system. 35 is conforming language. And then finally I think we're on the last page, Mr. Chairman. And so this is the other big amendment. And so we create a section 4 and say, we're just going to try this limited, 3 schools, and then provide a report back to Joint Education Committee, the superintendent of public instruction would. And then section 5 extends out the effective date to July 1, 2020. Let's see, 2022, I believe, yeah. Shall study 2022, and then it puts it into the Joint Education Committee in the interim to study this. And then section 6 just splits when it's effective. And I just want to say, we could have, frankly, we could have killed this bill, but we felt that it's been a long time since charter schools were debated and studied. And we thought that it would be appropriate to bring this bill out the way it is, to provide kind of some safeguards, to study this issue in the interim. We'll still have a bill in place, law in place, but we'll take a good hard look at it. And so, Mr. Chairman, that's what your standing committee amendment did, and I would certainly stand for questions on it. Thank you.
Thank you, Majority Floor Leader. Discussion on the amendment. Chairman Olson.
Yeah, thank you, Mr. Chairman. Mr. Majority Floor Leader, you kind of lost me at authorizer, but I'm going to trust you on everything else in there. My question is just about the decision on the authorizer. So the original bill, the authorizer of a new charter school was the SLIB board. Now, under this amendment, if we adopt it, the authorizer is going to be the superintendent following an election. I understood that to be because we want to draw it as close to the people as we can. My question is, when, at least in some, my cursory experience with charter schools, a lot of authorizers in other states tend to be city councils, for example, college trustee boards, university trustee boards. Just curious on your thoughts on those alternative authorizers, whether that was even part of the discussion, or just thinking about those authorizers as well, and wondering if they were part of the thought process. Mr. Chairman, thank you.
Majority Floor Leader, would you like to take them one at a time or take them all at once?
Mr. Chairman, my weak mind, I'll forget if I don't take them one at a time. My apologies.
Please go ahead, sir.
Mr. Chairman, thank you. And so obviously you could have a variety of authorizers. But in the end, I think it's something that has to be accepted and wanted by the people in that area, in that district. So I think by going to a vote of the people, you can do that. Do we have the specific debate on all of those others? No. We had a limited amount of time, and so we did not get into whether you could do a community college board or other boards. So no, we did not debate those.
Representative Schwartz.
Thank you, Mr. Chairman. I have a similar question for the bringer of the bill. I would like to understand what the role of the SLIB board is as an authorizer and how it interacts with the district in which the school will be located.
Majority Floor Leader.
Mr. Chairman, that's a really good basic question that I didn't bring up to begin with. So in current law, the only entity that can authorize the formation of a charter school is a school board. And it can only be done within that district. And then it becomes, it's a public school. These are all public schools, right? They get ADM. One thing this bill does, I didn't mention, that's rather unique, is if it's formed outside of the district by a different authorizer, then they'll only get 85% of the ADM. That was the way the bill was written. So the authorizer and the SLIB board, so what this bill did was say no. So in current practice, if you didn't like the decision made by the school board, you could kind of petition to the state board or the school board, I can't remember who, but you really couldn't ever get a third party to rule. And so I think the bringer of this bill's idea was the SLIB party would be, an unbiased party to perhaps be an arbiter of that decision. Our opinion was they're not going to be informed at the local level. These people don't deal in this, other than the state superintendent, who would be a part of that whole process. So I hope that answers that question.
Representative Simpson.
Thank you, Mr. Chairman. Folks, as a co-sponsor on this bill, we'd like to take a position. When we brought this bill was written by specialists in the area of the charter school processes. And we brought it to the Education Committee, and we recognize a lot of them are experts in this field. They've changed quite a few things with this amendment, but we're not opposed to that. We really wanted open dialogue. And so I'm actually speaking on and for the amendment. The objective of the bill is to open the doors somewhat so that charter schools feel comfortable coming to Wyoming. How that looks is up to us, and we're welcome to continue to work on this and improve it. But for a position on the sponsors of the bills, we're very happy with this amendment. We think that it continued to shape and move the charter school potential. So speaking on and for the amendment.
I don't think there was a question in there. Chairman Swanser.
Thank you, Mr. Chairman. I do have some questions, and I'm having difficulty wrapping around this idea, I guess, in the bill and what the sponsor said of a voting district. And I can't figure out what he means or what the bill contemplates as a voting district. I think he might mean what we consider a special district. But then I look at if it's not a special district require taxation, and you can't require taxation. So if we're not setting up a special district, and when you're not setting up a school district, I just need some more clarification on what this district is, how it gets drawn, and how it exists in law, and what it most resembles, because I can't get my mind to what it is. So if I get some more explanation on that.
Majority Floor Leader.
Mr. Chairman, thank you. So a voting, as small as it can be, is a voting precinct. As large as it can be is a school board district or a school district. And so then the application would define the boundaries. So the application that's brought forward would define the boundaries within the scope of those sizes and the combination of those. And like I said, the idea was if there was a small community somewhere that wanted to form up, then they could take multiple voting precincts, put them together, bring an application and provide that. So that's the idea behind it.
Representative Washit.
Thank you, Mr. Chairman. My question is with regards to the elections and the cost of the elections. It says that the cost will be borne by the people who are proposing the charter school. And I want to know, are you anticipating those will all be special elections? Or might it be possible to piggyback one of these elections on a primary or general election ballot where the cost might be less?
Majority Floor Leader.
Mr. Chairman and the good representative from the middle of the state, I appreciate that. And to be honest, I didn't have time to work out that many details. And so, I mean, I think that could be, obviously, if we study this, we're going to pick up all of these things, that questions like that, and try to solve those little pinwheels. But no, we did not solve that one. That's a good point. Thank you.
Madam Minority Floor Leader.
Thank you,
Conley.
Thank you, Mr. Chairman. And I'm in favor of the standing committee amendment. It makes a bad bill better, that's for sure. And in fact, but know that there are so many policy decisions in relation to charter schools, and the good majority floor leader took on 2 of them, and I believe did an excellent job. The way that the bill reads right now is that an authorizer, meaning the entities that says that a charter school can come into existence, that who authorizes the charter school. When it's not the school district, like it is now through that process, in the bill right now, it goes to the SLIB board. And I mean, I asked the question, the SLIB board has how many things on their agenda, and choosing schools is not one of them. And there will be no expertise there other than the superintendent of public instruction. And so turning it over to the superintendent and the Department of Ed makes a whole lot of sense, right? So much more sense than what's in the bill right now. And then the process that's being set up with the amendment makes a whole lot more sense than what exists in the bill right now. And if we get to the bill, I want to point out some of the other elements that we didn't get a chance to talk about. Again, this is an individual level bill that came this week, but on and in favor of this amendment, it is an amendment that moves us in the right direction. Thank you.
Thank you. Chairman Wilson?
Thank you, Mr. Chairman. Much as I hate to say it, I'm in favor of the amendment, and that's mainly because we want the bill to go forward. I've been working on educational options for children for some while. Back in 2015, I brought a charter school authorizer bill. It died in committee. So this is the first one that has lived a little bit longer. I have to say that with the standing committee amendment, it seems to say that a charter school is an option as long as it's just like the current system, which is an interesting form of an option. I liken the amendment to hiring a contractor to add on a bedroom because you're expecting a new baby, and then the contractor comes out and tells you they took out the fireplace, boarded over the windows, changed the brickwork to a hay bale construction, and now it kind of looks like the new baby's going to sleep outside in a tent. However, we're glad that the baby is coming. We knitted the little hair band already, so we're just going to shove this thing, there's no such thing as an ugly baby. We're just going to vote aye and move it forward and keep working on it.
Very good. This is still on standing committee amendment number 1. Representative Neiman?
Thank you, Mr. Chairman. On and for the amendment, it's like, I don't think I can be as eloquent as the previous speaker, but yeah, it's not perfect. But the idea behind it was this is the vehicle to be able to use to go forward and to provide some choice and some opportunity and some different things here that we're wanting to try to research, I've heard it put, a group genius here on where we can head on our education. And also it was interesting to me that we heard testimony in the committee meeting in regards to the fact that the Department of Education supports it. And so they came out and said that they do support the bill, that they do want to see this move ahead. And so that in and of itself, to me, also tells us that we've got some broad spectrum support for this. And so on and for the amendment.
Thank you. Mr. Majority Floor Leader, you want to wrap it up or go with the question? There we go. Question being called. All those in favor of standing committee amendment number 1, say aye. Opposed, no. Standing committee amendment number 1 is passed committee of the whole. Now we're on committee of the whole amendment number 1. Did you have? Okay. We have a committee of the whole amendment. Representative Andrew.
Thank you, Mr. Chairman. I move committee of the whole amendment number 1 to Senate File 130 and ask for your favorable consideration. This amendment simply changes which of the 2 enacting clauses applies to the amended language to the existing statute that you can find on line 15 of the amendment. By specifying that the section only applies to kindergarten through 12th grade, we allow charter school organizations to charge and operate a preschool which is not publicly funded. The reason this amendment is needed is that there is at least one charter school in Wyoming that is preparing to open a preschool this year in anticipation of the passage of this bill. The previous amendment unintentionally removed that possibility. On and for the amendment and the bill. Thank you, Mr. Chairman.
Thank you. Any discussion on the committee of the whole amendment number one? Hearing no discussion. Question being called. All those in favor of committee of the whole amendment number one, say aye. Those opposed, say no. Committee of the whole amendment number one is passed. We're back on the bill. Representative Walter.
Thank you, Mr. Chairman. My question is regarding the major maintenance and the capital purchase and lease side of it. In the current law, a charter school is paid for by lease is paid for by the state after 3 years of existence. So basically a charter school has to prove it can stay sustainable for 3 years. And then the lease, if they're leasing space, is picked up by the state. Prior to that, it's picked up by the school district because the school district is the only one allowed to create a charter school at this point. So now we're allowing the voters to, or the superintendent to start deciding if they want a new charter school that will then come on to the state's rolls for leases. Or if it is after if the building is purchased, if it's purchased within the first 3 years, it's purchased by the charter school. If it's purchased after 3 years, it's purchased by the state. That's the way it's currently working. The next question then becomes major maintenance. All of these facilities become the responsibility of the state for major maintenance. So now we're allowing one more entity or an entirely new entity to decide if a charter school comes about, and yet the state will be paying for the major maintenance on that. So I'd just like a little bit more discussion, because the state is already paying for the public side of the school system for major maintenance in buildings. And now we're allowing different folks to come in and after the 3-year waiting period, basically decide the state will pay for a second set of buildings to do the same sort of stuff. Just consideration. I still think I like the bill, but I'd sure like to know how this is all going to play out, because it will be an additional cost driver to the state when we start talking about the physical buildings, the major maintenance on those buildings, the leases on those buildings, or the purchase of those buildings.
Majority Floor Leader Summers.
Mr. Chairman, thank you. It's a really good point, and I don't know the answer. We took out the part where they could demand a school district building, but that piece, I just don't know for sure. There's a whole bunch of repealers, and I have that sheet, and one of it may be that, but I don't know the answer to that. So, and perhaps actually the guy that asked that question probably knows more about it than me, because he probably went and studied it. So maybe he has the answer himself. I don't know, but I'll find that out.
Representative Simpson.
Thank you, Mr. Chairman. Folks, we got off to a little bit of a rough start talking about charter schools. We recognize that many of us do not have any expertise in that area. So I wanted to just give you a little background. There are 7,500 charter schools in the United States of America. They actually educate about 6.5% of all of our students. We currently have state statutes. You're looking at it. That's part of what is in this bill. We have state statutes that provide and allow for charter schools. Now remember, a private school is something different. The state does not fund private schools at all. Charter schools, we do. Currently, we have 4 or 5 charter schools in the state of Wyoming, and we fund them to the tune of 100%, exactly using the same equation that we do in our public schools. This bill actually suggests that we're going to reduce that funding down to 85%. So if this bill passes, charter schools will receive 85% of what, 85 cents on the dollar of what our public schools. And the charter schools are telling us they operate on a different model, and they can do it for that. And so they're tickled with that. So what is the purpose of the bill then? Of those handful of charter schools that we have in the state of Wyoming, most of them are older charter schools. And the reason is because the entry level for a brand new charter school to come to Wyoming is so difficult so difficult to overcome, they're not coming. We heard testimony in the committee meeting that there would be many, many other charter schools that would be interested in coming to Wyoming if this bill passes and allows them a little bit more of a friendly way to get in and operate.
Thank you.
Charter schools.
Oh, sorry.
Charter schools can, I've got 20 more minutes, Mr. Chairman. Charter schools can be just like public schools. In Utah, in my daughter's neighborhood, a brand new charter school came in from out of town, headquartered out of California. They were a for-profit corporation, and they built a beautiful building, 2-story immaculate building. And they opened their doors and said, anybody that wants to come here. They had uniforms, although they're not the old style uniforms. They were cool shirts and polo shirts and shorts and cool sweatpants. The kids looked really cool in them, and they were more than happy to wear the uniforms. They typically do not have bus transportation. Parents carpool to bring their kids to school. And right next door, 2 years later, a brand new elementary school was built right next to it. It looked just the same. And they split the students and away they went. So that's a traditional type of a charter school. But there are other charter schools that specialize in very specific things. Let me give you an example. There was a young man in Idaho Falls that I'm aware of. He just struggled in high school. He just could not make it work, and he just refused to go to school and dropped out. His parents learned about a charter school, and they took him there and introduced him to what was going on. And it was geared towards vocational agriculture and vocational activities, technical schools. They just had a really, really nice shop, and all their classes were geared toward that. This boy agreed to go there, and he flourished and graduated from high school. So there is a niche that some charter schools can provide, a very specific focus and emphasis that are very successful kids that otherwise could perhaps struggle in our public schools.
Representative Yen?
Thank you,
Sorry, I
Mr.
thought you
Chairman.
were done.
Mr. Chairman, I'm happy to cede back to the co-sponsor if he would like to continue. If not, I mean, I ultimately have questions on the policy changes that we're presenting with the bill, right? So I did go to a charter school. It wasn't in the state of Wyoming. It was a type of charter school where it was a public school in the school district decided to adopt a charter. So the school district said, yeah, sure, you can have this charter. And so it became a charter school. So it's similar to the type of charter school that we already allow in statute, where the school district can approve a public school to become a charter school. So what I think this bill is contemplating, and maybe the co-sponsors can enlighten me, is on page 8, at the bottom of page 8, from lines 21 to 23, and then the new language on page 9, where we're allowing the election of a new sort of an organization to come in and establish a charter school in the same school district as a already existing public school. And so that's what my question ultimately is how does this affect the public school already in the school district if we allow an organization to come in and build a school and then they're essentially competing for the same students? What is the effect on an existing school if that happens? Thank you, Mr. Chairman.
Thank you. Let's go back to Representative Simpson. Apologies for interrupting.
Thank you. I'd like to address that. That's an important question because if a charter school came into just the right size of community and stole half of the students, it would create a huge financial problem for the existing district. There is no question that is one of the risks. I would submit to you, it's been discussed that perhaps the smaller schools really could advantage if the really, really small ones to even keep them alive, but I don't think that's the case. So here's the deal. For-profit charter schools are going to make a profit. They will not mobilize into a school district and try to steal half of the students because it's probably not going to happen and they'll be upside down and it just doesn't work. They're going to do their study. They're going to go into the Cheyennes and the Caspers, those sizes of communities, and start a school, and they're going to start with just the right amount of students to make sure that they maintain their profit margin and go from there. Members, I appreciate your consideration. I've talked too long at the mic. I encourage you to further this concept along with an aye vote on the bill.
Any further discussion on the bill? Representative Walter.
Thank you, Mr. Chairman. Now I have a little more concern. The good speaker just ahead of me was discussing his children's beautiful two-story building or multiple-story building built by an out-of-state company. And I just looked through all the repealers in this bill, and on the amendment, there are no repealers. I would still contend that the state is going to be required to pay the major maintenance on those buildings. So now an out-of-state company can build a beautiful new school, and because we haven't taken care of that condition, that issue on the facilities side of it, we might be paying to maintain a building that is far and above something that we would build for our public school side. And so that starts to create a little more concern. As I said before, I believe this bill certainly has merit, but I'm starting to have concern that it was structured for an out-of-state component, and now we're trying to cookie cutter it into what we have existing in Wyoming, and we're not looking at all of the other consequences that are going to come to the state and come to the state in a financial manner. And so I'd certainly like to have a little more discussion or a little more reassurance that this isn't going to become an overly burdensome financial drain on the state and the state's resources.
Chairman Nicholas.
Thank you, Mr. Chairman. In tagging on to the previous speaker, so we assisted in getting a charter school here in Laramie County, and so that was a few years back. But when we did it, we kind of did an economic analysis of what it's going to cost the school district, because there's no doubt that the school district will be impacted by it because they're going to lose students. So every one of those students, that's whatever, depending on how big a school it is, it's either $17,000 or $35,000 per AUM per student to go to this new school. In addition to that, you're going to have increased square footage for maintenance. So that's going to increase our budget. The budget that we just tried to cut by $80 million over the next 3 biennium for the school districts around the entire state. And those dollars will be coming out of our coffers. And so what I'm really curious about is has there been, and shouldn't there be an economic analysis of this process before we just say, okay, we're going to let someone start bringing in charter schools? Because there are real consequences. They were able to do it here because we had the largest school district in the state, and we were going to lose $300 or $400 per AUM at the end of the day. And we just figured we could afford it. But we did the analysis before we put it together. But I can tell you that it will cost your community, it will cost your school district. And what you also have is you get some particular type of schools, whether it is a semi-religious school or kind of the back to the basics, that will bring competition to the community and competition among teachers. And I would respectfully say that a private school can easily operate at 85% of what we do for all our other school districts. It's not like we do this thing on a per profit basis, but they'll get everything. They'll get buses, they'll get the cost for your extracurricular activities, all of those things. And so to me, it's an economic issue. And if you don't understand the economics, then I'm not sure that makes sense to pass a bill until we have that. And I'm really against the bill. I love the study concept and getting it done so we know what the numbers are. And every school district that may be interested in that knows what the numbers are before they have the opportunity. So thank you.
Madam Minority Floor Leader.
Thank you, Mr. Chairman. Friends, I want to let you know in my community, we have 2 brick and mortar charter schools. They are wonderful additions to our educational community. One is a Montessori school. The other is a, back to basics traditional school. Again, they are wonderful options. There is another wonderful brick and mortar charter school about a half a mile to the east from here, an academy. I am an advocate for school choice. I don't believe that all kids learn in the same way. So I also know that our statutes regarding charters, because they all had to go through an authorizing process, are old and wonky, right? 1995, right? And that's what we've been using. That being said, This bill attempts to rewrite basically all of them. We've spent a lot of time over the past couple of days talking about procedure, right? Wanting to do things right. And I'll let you know that this bill regrettably did not have the time to be vetted in any meaningful way. The good majority floor leader, he took on getting into our standing committee two small issues. No, two big issues, honestly. They were big issues, but they're more. I had questions in what I said to the bringer. If you turn to page 24, there's a couple of pages in there that are new additions to our statutes that would be if a proposed charter school that plans to be full-time virtual. I have 30 questions on just the components of these two pages, right? We have learned so much from the pandemic, and we have not vetted that one whit yet. But we're going to have pages of specificity about a virtual school to put in statute. That's not good policy. You turn to the next two pages, it's about bringing in a contract with an education service provider for educational program implementation, right? That's school foundation money. Who are we giving it to? Again, 30 questions on this section. We weren't able to do it. We almost passed an amendment that honestly stripped everything out of this bill other than 5 lines that would have had to be a study. That's what it really needs to be. And that's, I think, what we can promise you as the Education Committee. We will put charter schools on the interim committee because it needs to be, right? The statutes are old, they don't work well, but I don't want to put unvetted policy into our statutes with the hope that we'd come back and fix it later. That's not doing good work. So on and against the bill, let's send it to the interim and do that good work. Thank you.
Representative Duncan.
Thank you, Mr. Chairman. I'd like to pose this question. How many of our current homeschool choices would opt in to a charter school? Because maybe it would be fit more in line with the curriculum and such for those people versus the traditional school. So that's a question I'd like to know about the options and more schools of choice.
Mr. Majority Floor Leader.
So, Mr. Chairman, thank you. So the answer to that question, I left a lot of details out, but one thing in there is only 20% of the enrollment in the charter school can come from outside of the area of the charter school, outside of the district. So it kind of precludes that kind. There is a whole piece in there on a virtual charter school. And I don't really understand that. I'll be honest, I don't understand that piece. That's why we have to study it. But there is only 20% can be out from outside of the district. So I don't really think you're going to have an influx. We're not going to be creating a new, I can't say the name of the district, but we know there's 2 districts that have that. I don't think we're going to be creating another one of those. Thank you.
Madam Chairman Wilson.
Thank you, Mr. Chairman. I just wanted to clear up a couple of things that from previous speakers. These are not private schools. There's no religious component. These are public schools that are operated a little bit differently, but there's no component of religious teaching at all in them. And I would just say that we do have in the amendment, there is the requirement for a joint interim study and a study of it. I think that there are, to move this forward, to have this discussion, this bill is a necessary part of bringing about that discussion. And I think that it's providing options that, to be honest, the school system has kind of fought against for a while. And I think this is part of a necessary push.
Representative Yin.
Thank you, Mr. Chairman. So from what I heard from one of the co-sponsors of the bill is that this would allow a for-profit charter school, so a for-profit organization to come in and build a charter school where some of the students would come from the already existing public school district. And so I guess my concern there becomes, we had this long discussion about for-profit benefit corporations, but in a regular for-profit corporations, the goal is to maximize shareholder value, right? So if we have a for-profit corporation come in and build a school, I guess my question to the co-sponsors is how do we balance to ensure that we also have the best education for the students in the charter school, if the goal of a for-profit organization is to maximize shareholder value? And so that's ultimately my concern and a question for the co-sponsors. Thank you, Mr. Chairman.
Representative Neiman.
Thank you, Mr. Chairman. It's Nyman. That's okay. I was always told people just don't call me late for supper. That's all I ask. I think something that we want to keep in mind here too is this is an effort to try to provide something that I think is desperately needed in any situation, and that is the opportunity to have choice. Ultimately, what we're wanting to do here is to provide excellent education for our young people of this state. And this is part of that. This is part of being able to offer that and to provide those different choices that parents would like to have. And I think that what you look at sometimes when we're concerned about what is or isn't going to happen, but this has also been already explained, is this is under district supervision and charter schools. This is not a religious affiliation. This is simply thinking outside of the box in regards to education and providing other ways and other means of being able to provide that which is so desperately needed. And if it would potentially draw people into or away from other areas, it's still ultimately what we're here to do is educate our young and make sure that they get a quality education. And I don't think there's anything that's wrong in saying, there's a component to this, that competition creates excellence. It creates opportunity to be able to have challenges to do better and to provide those things, do a better job of providing them. I don't think we should be against that. I think we should be looking right now in anything that we do, as opportunities come, we need to provide that field, if you will, as good as possible of a planting, preparation of that soil as we can. And I think this provides that. If we can look beyond a lot of what we've always done and say, hey, maybe we need to start looking at some of these things differently. And I think that this, if you're willing, give this a chance and let this thing be worked and worked through and massaged and gotten to a point where it's going to do what we're hoping it wants to do. And that is ultimately provide an excellent education to the youth of Wyoming. With that, I'm on and for the bill.
Thank you, Representative Nyman. Good discussion. Representative Walter.
Thank you, Mr. Chairman. Just going back to the very last page of the bill and the repealers, and I hope some of you would take the time to look at some of the items being repealed. And I'll just use one example here real. And it's 21.3.305 subsection E. So let's read that. The contract between the charter school and the school district shall provide that upon the closure of the charter school, any charter school assets purchased with public funds shall become the property of the district. That's the process today. That's being repealed. So now my question becomes, so the state paid to buy a building or renovate a building for a charter school that's closed, and now the charter school is going to get to keep it and dispose of that asset and pocket the funds, I guess. As I read many of these other repealers, they're quite concerning. One of the others discusses the teachers' qualifications. We repeal the fact that the teachers at the charter schools have to meet the same standards that the teachers in our public schools meet. And so I would encourage the entire body to look at some of these repealers because they are quite concerning, and I haven't picked up in the bill where they are addressed elsewhere. But like I said, I still have concerns about the physical structures, so not sure what to do here.
Madam Chairman Wilson.
Thank you, Mr. Chairman. And I apologize if my answers are a little scattered. People keep coming up and asking me questions, and it's a little hard to keep track. Just working back and forward. So in the amendment, the Committee of the Whole amendment that we just passed, page 6 of the Committee of the Whole amendment, line 14, we have deleted the repealer that so concerned the previous questioner about the teachers' requirements. So that's, I mean, a lot of that was removed in the committee of the whole amendment that you just saw. And because there's so much conversation, I'm almost having a hard time remembering what the questions were. But Mr. Chairman, the, as far as the discussion about, gee, how terrible it will be if we have for-profit corporations coming in and possibly offering some education. I think there was a mention, but two of the three, at least two school districts in the state now basically have hired for-profit corporations to run their virtual education. One is a company that's actually traded on the stock exchange in the Big Apple, and another one is a private equity firm. This is happening now in our schools. When the schools have found some provider that they feel is adequate, they are doing that now. So I just want us to understand that these would be public schools. They are obliged to meet the same assessment tools and assessment and standards that all other public schools are. Okay, these are not dollars to private schools, which I actually had a bill on before, but it died. So that this isn't that. Okay, this is public schools in a different format, but needing to meet the same assessment standards as the current schools do.
Question being called. All those in favor of Chairman Paxton's motion when the committee of the whole rises to report, to do so with the recommendation that Senate File 130 do pass as amended. All those in favor say aye. All those opposed say no. Senate File 130 is passed the committee of the whole. Next file for our consideration. Oh, sorry, Mr. Majority Floor Leader.
Mr. Chairman, thank you. So I'm going to reorder. And it's not reorder dinner. There was two bills that were committee bills that came out of committee today and got read in. And so I'm going to pull them to the top. I might work till 5:30, but no longer. So the next two bills will be Senate File 15 and Senate File 28, and we will go no further than that tonight.
Thank you. Next Senate file for our consideration is Senate File 16. 15. Senate File 15.
Senate File 15, sponsored by corporations, temporary licensing and permitting authority 2, an act relating to professions and occupations. Mr. Speaker, your committee number 7, corporations, elections, and political subdivisions, to whom was referred Senate File 15 engrossed, temporary licensing and permitting authority 2. Respectfully report same back to the House with the recommendation that it do pass. Ayes. Representatives Blackburn, Clausen, Clifford, Duncan, Air, Hunt, McGuire, Roscoe, Zwanitzer. Representative Zwanitzer, Chairman.
What's your pleasure, Chairman Zwanitzer?
Thank you, Mr. Chairman. My pleasure is when the committee of the whole rises to report it, do so the recommendation that Senate File 15 do pass. There are no standing committee amendments, and I would turn it over to the good Vice Chairman of Agriculture.
Vice Chairman Clausen.
Thank you, Mr. Chairman. This is a fairly simple bill that came from the COVID-19. What we had was a bunch of issues where people couldn't get their licenses because of orders. A lot of medical type license or sub-medical licenses because they couldn't practice in person because of the orders, and this goes through and covers some of that. Fairly simple bill. If there's no questions, I'll stand for questions. If there's no questions, I'll call a question.
Question being called. All those in favor of Chairman Zwanzer's motion that when the committee of whole rises to report it, do so with the recommendation that Senate File 15 do pass. All those in favor say aye. All those opposed say no. Senate File 15 is passed to committee of the whole. Next file for our consideration, Senate File 28.
Senate File 28, sponsored by corporations, motor vehicles, security interest perfection, an act relating to motor vehicles. Mr. Speaker, your committee number 7, corporations, elections, and political subdivisions, to whom was referred Senate File 28 engrossed, motor vehicles, security interest perfection. Respectfully report same back to the House with the recommendation that it do pass. Ayes. Representatives Blackburn, Clausen, Clifford, Duncan, Air, Hunt, McGuire, Roscoe, Swanitzer. Representative Swanitzer, Chairman.
You've heard the reading of the bill. What's your pleasures? Chairman Zwanitzer.
Thank you, Mr. Chairman. I move in the committee of the whole rise to report to do so. The recommendation of Senate File 28 do pass. There are no standing committee amendments and would turn it over to the good Vice Chairman of Minerals.
Vice Chairman Duncan.
Thank you, Mr. Chairman. Okay. So this bill sounds more complicated than what it really is. All the parties interested in this, from your clerks to your lenders to your auto dealers, all came together to the table and had quote unquote a kumbaya moment. So what we're doing is basically, the issue is this: we're correcting the lag time between the time you purchase a vehicle and the time that the title is perfected and secured, as in filing at the courthouse. And what can happen sometimes is that because the state of Wyoming, you're allowed 65 days to pay your taxes. You're from the time you purchase your vehicle and you leave the lot, you could, in theory, before this bill, it took a lot of time between the time that they received the work from the lender, then they had to perfect the title, and they had to have all these different pieces met, and then they stamped it, and then they filed it. So it could take quite a while. Well, in the meantime, you could have like our situation that we have right now with COVID. You could have bankruptcies with big companies, and all of a sudden you walk in one day and you no longer have a job. And any number of things. So the lender at that point would not be made whole. So someone could file for bankruptcy. They bought the car, they filed bankruptcy. Well, this lien against the car hasn't been perfected yet and filed at the courthouse. So the lender is left out of the loop. So there is no lien then appropriately filed against the not mortgage, it's an auto loan. And what can happen is if the bankruptcy court won't recognize that, so then that vehicle will not then be the property of the lender. So the lender washes its hands of that, and then it ends up going back to the car dealer. So the car dealer is going to now have to go to the bankruptcy court. They're going to have to go through all of that. They're going to have to get to find out who actually owns the vehicle. So there's going to be fees involved with all that. Then after that, then they're going to have to take the time, hopefully get the vehicle back, and then eventually be able to resell the vehicle. So because of that timing and that lag in our statutes, we needed to correct that. And so what they did is instead is now that the minute the county clerks receive the documentation, they can stamp it as perfected, and then they can wait and make sure. And so the important part is on page 2, lines 11 through 13 and 15 through 22. These are all the steps that once those are completed, then that makes it to where the bankruptcy court can say, okay, these are set and the lender is secured, and they can move forward. So I don't know if I confused you more, but it's a really, really great bill. Everybody's really happy with it. And so I encourage you to vote aye.
Thank you, Representative Stith.
Mr. Chairman, no, the representative from District 5 is exactly right. SF 25 is a great bill, and it solves a problem. And here's how it works. Where this plays out is when a person files Chapter 7 bankruptcy, the trustee looks at the vehicle title, okay? And the only thing the trustee cares about is the lien stamped on the face of the title and the date that lien was stamped, all right? And if it turns out that either if there's no lien stamped on it, or if the lien date is after the bankruptcy petition filing date, the trustee takes the car, okay? Trustee grabs it, sells it. The bank loses, and sometimes the debtor loses too, right? So it's undesirable. What does this bill do? This bill fixes the delay that happens between when the bank gives the documents to the county clerk. Typically, the county clerk, they're not superhuman. It takes them a little bit of time to process the paperwork, right? So if while the county clerk is processing the paperwork, the car purchaser files bankruptcy, then the bank loses and potentially the purchaser loses too. Trustee gets the car, puts the money in his pocket, essentially. What this does is it says the time of perfection of the lien on the vehicle happens at the moment that the county clerk gets the paperwork and stamps it received, basically. So that's the innovation here. It solves a problem. Good bill, vote aye.
Chairman Greer.
Thank you, Mr. Chairman. I think I understand. I think I like it. I just want to ask a question with respect to a purchase money security interest, which is that protection for those lenders. So the comments that the banks are left out in the cold is not necessarily the case, because there is a remedy under Chapter 9 of the Uniform Commercial Code. So my question is, am I correct? It's been 30 years since I've had to work with this, but also we're not creating any confusion between our titling a vehicle section and then what is dealt with in chapter or Article 9, excuse me, the Uniform Commercial Code. So I just want to be clear that I understand that we've thought through all this and we're not making a mistake by the kumbaya moment stuff, which typically never works out well for me.
You want to respond?
Mr. Chairman,
Representative
yes, in
Stitt?
fact, with respect to Article 9, in the committee process, we actually incorporated a footnote that's in Article 9 where the drafters of the UCC recommended that states do it this way. So this is actually updating it to the way the comments of the UCC suggested that we do it. So I think it doesn't create a problem. It should solve a problem.
Vice Chairman Larson.
Thank you, Mr. Chairman, and to one of you, I guess I'm just trying to follow that UCC filing procedure. So does the title need to be perfected before the UCC application takes place or that filing takes place? Can you just walk me through that? You know, I'm just trying to put these components in order of chronological order.
Representative Stitt.
Mr. Chairman, so UCC filings filed, say, with the Secretary of State's office in Cheyenne, that's for equipment, not titled vehicles. This bill, of course, deals with just titled vehicles. This is just titled vehicles. And our law of perfection is that your security interest in a vehicle is not perfected until the lien is stamped on the face of the title, right? That's current law. And the issue is, when does that stamp get put on there? And the problem and sort of the logistical problem for the county clerks is that they might have a 7, 8, 10-day backlog because they're not superhuman. They can't do it immediately. So now you've got this 7 or 8, 10-day lag time. And if a person files bankruptcy during that lag time, the bank loses its security interest because the trustee in bankruptcy steps in front of the bank, right? It's all about who gets to step in front of the bank. So what this bill does is it says that the county clerk is going to be obligated to note the date and the time that the bank tendered the documents to the county clerk, and that'll be the date of perfection. And this does not actually protect the banks from their own screw ups, because that happens too. We didn't talk about that much, but every couple hundred cases, the bank delays in getting the paperwork to the county clerk and loses as a result of that. This bill doesn't fix that, but it's up to the banks to control that risk.
Discussion on the bill. Chairman Zwanzer.
I would like to also mention that the organization that represents banks, the organization that represents credit unions, the organization that represents automobile dealers, and the association of county that represents county clerks all came together, reviewed this through the interim, and are all confident in the language that it does a good job. And I just wanted to thank the good Vice Chairman of Minerals for her amazing explanation of the bill to begin with. I would call the question.
Chairman Greer.
Thank you, Mr. Chairman. Before the gentleman, I just do have one more question regarding this, is that this will not in any way make a purchase money security interest inferior, because there is the possibility that money is loaned for the acquisition of the collateral, the vehicle, and where another security interest could come in. So we are not making that purchase money security interest inferior by doing this. And there are relatively complex transactions that happen out there outside of someone going, the average person going and buying a vehicle. There are more complex transactions that exist, and I just want to make sure that we're not doing away with that purchase money security interest priority.
Representative Duncan.
Thank you, Mr. Chairman. Chairman Greer, we will get back to you and we'll make sure that that doesn't happen. Please vote aye.
Hearing the question, hold on. Members are reminded, please don't use the proper name. Thank you. Representative Stith, did you have something else? Wrap it up. Bring it home.
Mr. Chairman, I would just say that the representative from District 27 is correct, that this does not diminish the purchase money security interest priority.
Question being called. All those in favor of Chairman Zawanicher's motion that when the committee of the whole rises to report, do so with the recommendation that Senate File 28 do pass. All those in favor say aye. All those opposed say no. Senate File 28 is passed committee of the whole. Majority Floor Leader Summers.
Mr. Chairman, thank you. Mr. Chairman, I move that the committee of the whole rise and report.
You heard the motion. All those in favor say aye. Those opposed say no. That's a hard call. I'm going to say aye. Majority Floor Leader.
Reading clerk will please read the committee of the whole report.
Mr. Speaker, your committee of the whole, having had under consideration bills on general file, begs leave to report as follows. Senate File 34 do pass. Senate File 157 do pass amended. Senate File 130 do pass amended. Senate File 15 do pass. Senate File 28 do pass. Representative Henderson, Chairman.
Representative Henderson.
Thank you, Mr. Speaker. I move the adoption of the committee of the whole report.
You've heard the chairman's motion. All those in favor, please say aye. Those opposed, no. Congratulations, Chairman Henderson. Thank you. Reports from standing committees.
Mr. Speaker, your committee number 4 education, to whom is referred Senate File 127 engrossed, Wyoming Learn While You Earn program, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Andrew, Brown, Connolly, Harshman, Nyman, Newsom, Obermueller, Paxton, Summers. Representative Paxton, Chairman.
Thank you. Messages from the Senate.
Message 359. Mr. Speaker, the Senate did concur on House amendments to the bill listed below by the vote indicated. Senate File 115, Education, Pupil Teacher Contact Time. Ayes 29, excused 1. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 360. Mr. Speaker, Senate File 87, Voyeurism Amendments. The Senate failed to concur on House amendments to the bills listed above by the vote indicated. Ayes 0, noes 30. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 361. Mr. Speaker, the Senate appointed state conferees to meet with the like committee number 1 from the House on amendments to Senate File 87. The Senate conferees are Senator Cost, Chairman, Senator Nethercott, Senator Schuler. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 362. Mr. Speaker, House Bill 17, Range Management at Military Training Areas. The House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 30. The Senate respectfully asks the House to concur by adopting the listed amendments. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 363. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 41, Intrastate Crowdfunding Exemption Amendments. Ayes 30. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 364. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 43, Digital Assets Amendments. Ayes 30. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 365. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 179, Optional Municipal Tax Election. Ayes 16, noes 14. Sincerely, Ellen Thompson, Senate Chief Clerk. Mr. Speaker, message 366. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 195, Wyoming Medical Review Panel repeal. Ayes 30. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 367. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 197, Connect Wyoming Program, federal funding. Ayes 29, noes 1. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 368. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 198, University Water System. Ayes 21, noes 9. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 369. Mr. Speaker, House Bill 207, Coal-Fired Generation Facility Closures, Litigation Funding. The House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 26, noes 4. The Senate respectfully asks the House to concur by adopting the listed amendments. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 370. Mr. Speaker, House Bill 229, Livestock Identification Choice Act. The House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 30. The Senate respectfully asks the House to concur by adopting the listed amendments. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 371. Mr. Speaker, the Senate appointed Senate conferees to meet with the like Committee Number 1 from the House on amendments to House Bill 22. The Senate conferees are Senator Landon, Chairman, Senator Anderson, Senator Pappas. Sincerely, Ellen Thompson, Senate Chief Clerk.
Mr. Majority Floor Leader, that clears the desk.
Mr. Speaker, I move that the House adjourn until 10 a.m. tomorrow, the first day of April, 2021.
I think that'd be a national holiday, but all right. Committee announcements. Chairman Eklund.
So for the Ag Committee, we will meet upon adjournment tomorrow to discuss interim topics. And also I would like to remind anybody on select water that we'll have a select water meeting at 8 o'clock in the morning.
Thank you. Chairman Olson,
Yeah, thank you, Mr. Speaker. Actually, I have a privilege of the floor.
please proceed.
I just want to take a moment to, thank everyone who served in the committee, the whole chairmanship thus far, and we're winding down our days, so we only have so many days left. And, our chairman that served today, he did an amazing job, and he had come to me and he had served in the Jonah building, but he hadn't served in the Capitol and really wanted to serve in the Capitol. And so there's different reasons why people serve in that chairmanship. And so as we wind down and only have a few days left, I know there's still some newer members that haven't had that opportunity yet, but remember, we still have one more session as part of the 66. So if you haven't touched base with me on that, I'd really appreciate that if you're interested that you do, because and if you've served in the Jonah building, this is to some of the older members, but haven't served, mostly from my class that came in at that time, but haven't served in the Capitol, I'd really encourage you to come to me on that as well. And I think Representative Henderson could share his experience and just how different it is chairing in the Jonah versus in the Capitol, and just, I just think everyone has done an amazing job that's been up there in the chair, and just want to, Representative Ottman came to me and thanked me for really, actually, I kind of pushed her along to get into it, and she really enjoyed it. And so if you haven't, please come to me, and thank you to all of our committee, the whole chairman that we've had so far.
More announcements. Chairman Burkhart.
Thank you, Mr. Speaker. Your committee number 8, Transportation, will meet tomorrow on noon recess to discuss interim topics with our brethren from down the hall.
Thank you. Any other announcements? Other announcements? Chairman Zwanitzer.
Thank you, Mr. Speaker. Corporations will meet with our like counterparts at 8 a.m. tomorrow in EO6.
Thank you. Chairman Nicholas.
Thank you. Your House Appropriations will meet on adjournment, on re-referral, Senate File 122.
Chairman Harshman.
Thank you, Mr. Speaker. Your committee number 3, it's 3. It's been so long since we met. Revenue will meet with our counterparts tomorrow at noon to discuss interim topics.
Further announcements. So members, just to take a look at your email, Chief Clerk sent you 3 concurrences we'll take up tomorrow. And anything else further good? Anything else? All right, members, you heard the majority floor leader's motion that the House stand in recess until Thursday, April 1st at 10 a.m. All those in favor, please say aye. Those opposed, no. Hold on, I'll belay that just a second. Mr. Majority Floor Leader.
Mr. Speaker, thank you. So to give you a committee of the whole list for tomorrow, Senate File 38, 112, 121, 76, 127, 152, and then 68, and from there we'll go on. So I'm going to repeat that. 38, 112, 121, 76, 127, 152, and 68, and then others as determined.
All right. All those in favor of the motion to adjourn, please say aye. They're not near as enthusiastic. Those opposed? We are adjourned. Well done, members.